each month I have paying the maintenance.
RSA you.
RS.
Do.
And one is money.
No, one.
ठीक है.
Pardon to mention, your lordship, this is ABLAPL number 9752/24. This is the fresh matter, lordship. Other 7 co-accused are already released on bail, lordship. Kindly release this matter tomorrow.
Not tomorrow.
Bail application has been dismissed for non-prosecution. Previous occasion I have also filed an member of the suggestion and reports but
Give them.
It's a fresh matter, your lordship, for transfer of case because the third ADJ at Cuttack is not functioning since long.
Give.
My lord, item number 20. On
which
behalf
list?
of Mr. A.R. Mishra, praying for next
Which list, sir?
supplementary.
Item number 20.
21.
No, this is 2013 matter.
My lord, he is suffering from fever.
Who is suffering from?
Mr. A.R. Mishra.
Who is the petitioner?
I have taken consent.
No, let it reach. Let it reach, we'll see. Yes.
Supplementary list, item number 1, fresh application. If the husband has filed this case, my lord, for transfer of the DBA petition filed by the wife in the Raulkela, SDJ Mudit Nagar to Barampur, my lord.
Yesterday this matter
The
was.
same matter, my lord. Yesterday that was there for the
That matter, my lord, I have appeared for the wife. I have filed it to RPC.
You have filed a?
PRPC.
PRPC, that
Where
is
my lord is directed.
where my lord has been directed to for a conciliation. Conciliation is.
Oh, so this matter will also go for
No,
conciliation.
Yes,
All
ma'am.
right.
Yesterday item 2 was there.
It is submitted, it is stated at the bar that the the matter, that the dispute has been sent for mediation in a connected transfer application. Stop. In such view of the matter, let the records of this case be placed before the coordinator Odisha High Court Mediation Center, who shall place the same before the mediator dealing with the matter.
20th,
28 is the date.
Place this matter after
First
on 1st October.
Item number 2,
item 2, ma'am.
agent petition the husband my lord.
Yes.
File CRP number, file a petition for transfer of the CRPC number 205/24 pending before the Law and Family Court to Law and Family Court of Kottaka due to the present petition army officer. The myself filed a petition for before the Law and Family Court Kottaka for restoration of a conjugal life. My wife filed interim maintenance. There is a more chance of a reunion. Both party appear before the mediation center. There is more chances, man. Notice
No.
there is more chance.
No, Mr. Bera. No.
Army officer both ଏଠି ଗୋଟେ କଟକରେ ଗୋଟେ ପ୍ରୋସିଡିଂ ମୁଁ ଫାଇଲ କରିଛି ସେ ୱାଇଫ ମତେ ମୋ ମନରେ ମେଟା କିନ୍ତୁ ମୁଁ ଗୋଟେ ଆର୍ମି ଅଫିସର ରାଜସ୍ଥାନରେ ମୁଁ ଚାକିରି କରିଛି ଆଜ୍ଞା
ये कटक कौन भुवनेश्वर
ରାଜସ୍ଥାନ ଚାକିରି କରିଛି ଏକାବେଳେ ଛୁଟି ଦିଟା କ୍ଲବ ହେଇଯାନ୍ତା ଭଲ ହୁଅନ୍ତା ମୋର ଚାନ୍ସେସ ମେଡିସିନ ସେଣ୍ଟର
No. The petitioner.
ଆସୁ ମେଡିସିନ
No. The petitioner seeks transfer of. No. The petitioner seeks transfer of criminal proceeding number 205 of 2024.
କ୍ଲବ ହେଇଯାଉ ଆଜ୍ଞା
Pending in the Court of Learned Judge Family Court 2, Bhubaneswar, to the Court of Learned Judge Family Court, Cuttack. Therefore, transfer has been made on the ground that another proceeding is pending between the proceeding is pending at which place?
Family Court Kottaka.
At Cuttack. Being filed by the petitioner's wife. Stop. It is further submitted that the petitioner, being an army personnel, is posted at Rajasthan, and therefore it will be difficult on his part to attend to the family court at Bhubaneswar. Considering the grounds raised, I do not find any justified reason to allow the prayer for transfer. The transfer application is therefore finished.
Hello.
It shall be open to the petitioner to seek virtual mode. Yes.
Yes, sir.
Pardon to make a mention. Weekly list item 8, my lord.
This is not the time to mention.
My
Sir.
lord.
This is not the time to
My
mention.
lord, Brief already transfer from us, my lord.
You just wait. When it will be called out, you will say.
Well.
Please maintain some decorum.
Item number 3.
Yes, item 3. I've sought for transfer of the 1cc case number 24 of 2022 from Lord JMC Borpali to Lord SDM Patnagod. That offense under 138 of the Act.
Why?
Lordship, see, the first which is distance factor 160 kilometers. Secondly, I was working in a construction company at
You are the accused.
Yes, I am the
You are the accused. You are not required to attend every day. You can pray for 205. You can pray for 205. No. You can pray for 205 and you are not required to appear every day as an accused in this case.
No, more. Yes, most of the documentary evidence.
Documentary evidence. Kau kare?
Or virtual mode.
No, virtual mode kahin.
Because my life is at stake at the hands of the complainant.
No.
No.
If your life is at stake, file a lodge an FIR.
None of the members from Borpali bar they are cooperating me.
No.
Once I had appeared through the advocate from Patna Bar.
The petitioner seeks transfer of 1cc case number.
You say that BC.
No. 24 of 2020. It's open to you. You may apply if I don't think 138 NI Act. This is family court matters. They have specific provisions.
Yes, that
24 of 2022. From the court of learned JMFC Borpali to the court of learned SDJM Patnagar. The petitioner is the accused in the said case. It is stated that Borpali is at a distance of 160 kilometers from Patnagar, and therefore it would be difficult on his part to travel to Borpali from Patnagar on the dates of posting of the case. Stop.
moreover the second now that Borpali no kono bar member mate cooperate karu nahanti.
Further, no member of the Borpali bar is cooperating with the petitioner. Stop. This court, and after hearing learned counsel, after considering the grounds raised and the pattern, after considering the submissions, this court does not find any justified reason to grant the prayer for transfer. For the reason that the petitioner being an accused in the complaint case, he can always seek exemption from personal appearance by making necessary application under section 205 of CRPC. Stop. Further, if no lawyer from Borpali is willing to represent the petitioner, said fact can be brought to the notice of the court, whereupon necessary orders can be passed. That apart, the petitioner can also appear through virtual mode by seeking necessary permission of the court if such a contingency arises. In such view of the matter, I am not inclined to allow the prayer for transfer, which is therefore dismissed. Yes.
Item number 4.
This one is the wife, my lord, seeking transfer the CP case number 16 of 2024 from the Court of Lawrence Judge Family Court, Sambalpur to Lawrence Judge Family Court, Barbar.
50 kilometers away.
The petitioner is the minor child, breastfeeding child. They are minor. I am starting in paragraph 5. Paragraph 4, my.
All right. Notice. Stay. Date karo?
6th November.
6th November.
Item number 5.
Hello, I filed the present DRPC, my lord. Transfer the CP case number 212 or 24 filed by the opposite party, section 9 of Hindu Marriage Act. The Lawrence Judge Family Court of Borom.
All right. Take notice. Notice. Stay. 5th November. 6th November.
Item number 6.
And for the wife, my lord, I have filed this application for transfer of the application. Bhubaneswar to Khordha, my lord.
Bhubaneswar to Khordha?
Yes.
No.
Since a criminal case is pending before the judge family.
Bhubaneswar to Khordha, Bhubaneswar to Cuttack. These are places we should know.
I am for the wife.
I know. So
Let
what?
them,
So what?
I'll take notice, my lord. Let the husband will appear, my lord.
No, unnecessarily this will be interfering with the matter.
Since a application, FIR was lodged at Jankia police station, I am belongs to Khorda, my lord. That case was pending before the SDGM Khorda. Knowing the said fact, my lord, he has filed the application before the Bhubaneswar, my lord, husband.
All right. Notice, stay 5th November,
Obliged.
6th November.
Item number 7. Here for the releasing of the maternity leave amount, my lord.
Yes.
Maternity leave amount. Dispensation order annex 3 is pending.
What is the fact? What are the facts?
That's my says she has a Angan period as claiming for the release of the amount, madam.
What amount?
Maternity leave period.
What is the guideline in this regard?
Yes. As per guidelines. Right.
Whether it can be treated as a maternity leave or not. Yes. What are your instructions?
Instruction is going for the first time.
So you take instruction. If necessary, we'll direct them or representatives will dispose of. Learned State Council shall take instructions whether the government guidelines permit payment of salary to the Anganwadi workers in lieu of maternity leave. Place this matter during maternity leave. Place this matter on 25th September. Instructions be obtained positively. This is just instruction. You refer to there will be no guidelines, as I'm quite sure, but just refer to that book. There are many, circulars, clarifications, and all those things. Just go through it.
Not there in the book,
But generally, if she is entitled to maternity leave, then she is also entitled to the salary for that period. I have held in a judgment that denial of maternity leave amounts to violation of Article 21. There is a reported judgment also. Yes.
Item number 8.
At highly representation disposal of कौन होगा ये? आपको client to कौन आधा brief ये तो complete justice दो पे चेष्टा करो तुम ये representation disposal कौन मिलेगा हमारा हम हाई कोर्ट के तो बंधना में जानी चिंता है आउट कहीं ऐसी जो एटी ही परिबो जो नहीं परिबो ठीक है हम रिप्रेजेंटेशन में
कंसीडर आले
जो ना एटी मैडम इशू करियो की कथा कहीं व्यस्त हो जो if you can prove that she is entitled to that amount
I am verified
in law, then that order will be passed.
It's rightly entitled.
And then why are you asking for a representation? You are not asking for that. Yes.
Item number 8.
My lord, the petitioner is working as a hormonal worker, my lord. Under Annex 6, page 34, she had not received the salary from March 2018 to October 2018 and June 2019. And also, she had not received the SNP price, which is being held since March 2018. But without paying the salary and without giving.
What is this SNP price? SNP price?
SNP price ଆସିଲେ ସେଥିରେ ପଇସା ଆସିଲେ ପରିବା କିଣା ହେବ ଆଉ ଡାଲି କିଣା ହେବ ଡାଲି କିଣା ହେଇକି ରୋଷେଇ ହେଲେ ପିଲା ଖାଇବେ ସେ ପଇସାଟାକୁ ଆଉ ସିଡିପି ଆକାଉଣ୍ଟ ଦଉନି ଯୋଉ ଆକାଉଣ୍ଟ ପଇସା ଦେଲେ ୱାର୍ଡ ମେମ୍ବର ଆଣ୍ଡ ୱାର୍କର ଅଙ୍ଗନୱାଡି ୱାର୍କର ଦୁଇ ଜଣ ଜଏଣ୍ଟ ଆକାଉଣ୍ଟରେ ଦସ୍ତଖତ କରି ପଇସା ଉଠେଇଲେ ପରିବା କିଣା ହେବ ସେ ପରିବା କିଣା ହଉନି କି ପିଲାମାନଙ୍କୁ ଖାଇବାକୁ ଦେଇ ହଉନି ଆଉ ଆମେ ସେଥିରେ ପାରାଗ୍ରାଫ 3 ରେ ମୁଁ ଲେଖିଛି rice has not been supplied to the center since February 2019. So the center is running by borrowing rice. Anganwadi worker ଗୋଟେ ଦୋକାନରୁ ବାକି କରି ଆଣି ଚାଉଳ ଆଣିକିରି ପିଲାମାନଙ୍କୁ ଖାଇବାକୁ ଦଉଛନ୍ତି till today ଆଜ୍ଞା ଦଉନାହାନ୍ତି I have made representative before the grievance before the collector at district magistrate Keunjhar, but till yet that matter has not been sought out. And thereafter one notice was issued by the CDPO under Annex 13. You have not done your duty properly. So why action shall not be taken against you?
No, you take
Against,
instruction. Take instruction. There is something else in this matter.
Yes, ma'am.
It is not as innocuous as it looks or sounds.
Yes, ma'am.
Learned AGA accepts notice on behalf of all the opposite parties. Let a counter affidavit be filed within 4 weeks. Close this matter. Huh? On 23rd October. Yes. IRA notice as above. Yes.
Obliging.
Now, 9, pleasure lots. The petitioner will continue as Anganwadi helper.
Anganwadi helper. Yes.
Engaged on 3/8/2001 at page 11.
Yes.
Casual vacancy arose on superannuation of Anganwadi helper May 2024.
Anganwadi?
Worker.
Yes. In that same
center.
Yes.
So as per the guideline, the petitioner having requisite qualification and fulfilled, yes, she has to be engaged as Anganwadi worker.
No, she has to be, there has to be a selection process.
Selection process, your lordship meant the guidelines says.
Hold on.
Selection process, if selection process will continue, then it will not. The clarification, 2024, a clarification has been proceeded. Previously, she shall engaged. Previous initial there was the 2023 modified only consolidated.
Will remain eligible for promotion as per the provisions applicable. Then, subject to other conditions as prescribed by the state. So
once the fulfilling the criteria,
there cannot be any straight straight away there cannot be any direct engagement. It has to be by way of a selection where you will be given preference, provided you are suitable in other respects. That is the law. Really?
the mark basis is not possible.
No, Anganwadi helper and organizer, if having the requisite qualification
Yes.
and are found to be suitable,
Yes.
suitability test among others, suitable suitable.
Then the clauses enumerated, then it will be redundant.
What will be redundant?
Because there is a marks basis, selection in the mark
Yes.
basis. Then in the provision enumerated that.
Oh, if she has the requisite qualification, then no mistake.
Qualification is matriculation that we have provided.
Yes.
They are having experience.
Yes, that will be given by extra weightage as compared to other candidates. Since you have already worked as a Anganwadi helper and more so in that particular center, you will be given more weightage. You will be preferred.
There is the guideline does not reflect that weightage about.
No, not weightage.
The fresh candidate asijibe. The mark basis.
No. If Anganwadi helper was to be straight away promoted or appointed as Anganwadi worker, then there was no provision. There was no necessity to have this provision at all. And are found to be suitable. So this expression means that it presupposes there is a selection process. Suitability test. Suitability has to be ascertained, and suitability cannot be ascertained by from a single person. It has to be within comparison to others. So
Then the phrase and the helper will compete with each other. Then suitability will come in the preferences mark. There is selection process.
He may not be selected. He may be selected, may not be selected. There is no such rule which says that she is bound to be selected. There is no such rule.
She shall.
So overall year padhibe na khali seti padhibe and are found to be suitable. Jodi suitable hele mane if she crosses the suitability test,
having the requisite qualification are found to be suitable shall be selected.
Yes, shall be selected mane
and worker provided they have worked for more than 5 years.
Yes sir. So, pratham katha la they have to have requisite qualification. Then if they have the requisite qualification, they can participate in the suitability test. If they are suitable, they will be engaged.
That case of my humble submission.
Yes.
Their suitability is only will consider on the basis of their.
No.
If you will be compete with the I may be.
No.
Then the clauses of the provision who has worked more than 5 years or 10 years, 12 years, 18 years. If they will be compete with the fresh candidate,
Then there is a provision of procedure of enumerated on the guideline for selection that the mark will be awarded. Then normally the mark which will be awarded to the fresh candidates having more qualification than these matriculation students, those are engaged prior to revised guideline 23. They will be normally get less mark than that. They will not compete with them.
No,
in
they
mark
can.
basis.
No, whatever. That is the.
So when they are normally in all other centers are normally they are giving promotion. One of the engagement order issued in the recently 24 by virtue of this Hon'Ble Court I have enclosed also. In other centers they are providing.
I don't think so. I may not.
The
Privacy, I'm not agreeable. You take what is your prayer here?
Therefore, engagement as Anganwadi worker keeping in woman experience and other eligibility.
How can a mandamus be issued in this regard?
They have,
Very
they
difficult.
are not considering that they should have the selection committee should have considered on the basis. The other centers they are providing some of the centers projects they are not providing. One of the engagement under Annexure 5 recently 24 in our center under the ICDS project I have provided. They have provided this in keeping in view of that.
No. I do not agree with your interpretation. Anyway, that's a different matter.
Once they will be compete with other on mark basis, they will be they will not get the provision enumerated with in a pragmatic keeping in view of the pragmatic so that the workers who are there. So
What will happen is then that Anganwadi worker, wherever there is an Anganwadi helper, then for Anganwadi selection of Anganwadi, there will be no selection for Anganwadi worker at all. If your claim is to be accepted, your interpretation is to be accepted, that will remain closed for all times to come forever.
no. All times go for suppose worker working more than 10 years, 12 years, 20 years. For certain period, 10 years, 12 years, then certain.
It has to be Anganwadi selection of Anganwadi worker has to be by way of open advertisement and selection. In that selection, you will get some preference because you have already worked as an Anganwadi helper. But
in preference basis, that the provision enumerated their mark basis. Am I submission? If this Anganwadi worker was there in the matriculate, suppose the press advertisements, new standards will be applied. Then there normally be nowadays after graduation or some higher.
तामने जो जगह जो अंगनवाड़ी सेंटर रे हेल्पर काम करते हैं से जगह अंगनवाड़ी सेंटर रे जतले वैकेंसी ऑफ अंगनवाड़ी वर्कर आउ से सिलेक्शन होबो नहीं याको ही केवल प्रमोशन दिया जाई पिरे no that is not
in order to accommodate them to into their experience these clauses
that will be
otherwise
that will be violative of Article 14 of the Constitution because you are restricting it to only one person. You can't do that. And is found to be suitable. Suitable, what I use suitability test.
So far the guideline concern, when the mark, basis of mark awarded, there is no provision of where the Anganwadi worker helper having experience, what mark will be awarded to him at the time of selection. That is absent in the procedure, absent in the selection.
You take instruction. You apprise the court accordingly, but prima facie I don't agree. I don't agree with Mr. Mahathi's.
By that time, if everything is over,
not till that no over. Till then the selection process is not over. They see an instruction till
has an advertisement been issued?
Issued, but no selection.
You can participate. I'll say that pendency of this writ application will not be a bar to the petitioner to participate in that selection. That I will say. But you have not filed any IA anyway. I can say that. Leonard's AGA accepts notice on behalf of all the opposite parties. Let a counter affidavit to be filed, particularly highlighting whether an Anganwadi worker, Anganwadi helper can be straight away appointed as Anganwadi worker of the same center if she possesses the requisite qualification and has rendered and has been working for more than 5 years. Please this matter.
Any short date maybe so that
Short date karo. Short date karo.
let them show finally.
Speak of October karo. 3rd October. It is submitted. It is stated at the bar that a selection process is underway. Stop. Such being the case, this court observes that pendency of this writ application shall not be a bar for the petitioner to participate in such selection process. Yes. No.
Item number 10.
May I please for yours? My lord, the petitioner is the one of the applicants for the Anganwadi worker, my lord, in respect of the Makunpur 1 Anganwadi center of the Chakradharpur Gram Panchayat under Dharmasala ICDS project. My lord, your lordship have a glance in page 38. The present petitioner along with others, a total 9 candidates are there in petitioner number, serial number 6 is found place in the online application by annexure 3 at page 38. And thereafter, my lord, they have selected selection list when they published, my lord, annexure 6, my lord, at page 41, my lord, total 7 candidates in the total final selection list was there. The present petitioner along with another candidate was not, my lord, in this selection process. How they have not, they have in remarks column, they have not assigned any reason for they have not selected.
No, is your name found place here?
Yes, page 38, I am the applicant, one of the 9 at serial number 6, my lord.
Serial number 6,
My
page
lord.
38.
Puspalata Pradhan,
Puspalata Pradhan.
Makunpur 1.
Now here your name doesn't find.
No, my lord, in selection list,
then what
there is
happened?
9 candidates, here is 7 candidates.
So you can file an appeal. You can challenge this. You can challenge this before the.
I don't know, in debarring my application in where, my lord, they have not, why they have not.
No, you have not been selected. Somebody else has been selected.
Yes, one selected in out of 7 candidates, serial number 5 is selected in remarks column they have given.
All right.
My application is not in appearing in the selection.
All right. So you can bring it to the notice of the appellate authority. Because this is challenging the selection.
My lord.
Or engagement of this.
My lord.
You have to file an appeal, that's all. File an appeal and you will have a remedy of second appeal also.
My lord, here is a total illegality committed in the online application.
That's all right, but that can be considered. Why should this court interfere into that? The appellate authority can consider. The petitioner was one of the applicants for the post of for engagement as Anganwadi worker of
Makunpur
1 Anganwadi center
of Chakradharpur Gram Panchayat under Dharmasala ICDS district of Jajpur.
It is a grievance that the selection committee selected one Priyanka Pradhan as the Anganwadi worker, but the name of the petitioner was not considered by the selection committee as reflected in the career marking statement of all the candidates prepared on 5/8/2024. Stop. As it appears, as is evident, the petitioner is aggrieved by the selection of said Priyanka Pradhan as an Anganwadi worker and her non-selection as such. Stop. This is a matter that can be agitated before the appellate authority as per the revised guidelines dated 15/3/2024. The writ application, since alternative efficacious remedy is available, this court is not inclined to interfere in the matter and to prefer appeal before the concerned appellate authority as per the guidelines dated 15/3/2024 within 2 weeks from today. Stop. If such appeal is preferred, the same shall be considered in accordance with law as early as possible. Preferably within a period of 2 months thereafter. Stop. It goes without saying that the appellate authority shall grant opportunity of hearing to all necessary parties. Stop. It shall also be open to the petitioner to pray for such interim relief as he may desire. Yes.
Item number 11.
Item 11, may I please the lordship?
Your Lordship, here petitioner is the applicant for the engagement of Anganwadi helper, and two applicants were there, Your Lordship. As per the advertisement dated
ये तो कौन सा advertisement? निकले? It advertisement is.
24/7/2023, page 26, Your Lordship. As per the advertisement, Your Lordship, both the candidates, applicant number 1 and applicant number 2, both were selected, and the petitioner was
Page 26 is the advertisement.
6 years, Your Lordship, the advertisement, Your Lordship. And Your Lordship, here the petitioner name was listed in the first list as per the eligibility criteria. She
Where is
was
that?
selected.
Where is that?
Your Lordship, Annexure 8, Your Lordship.
Hmm.
38, Your Lordship.
What is your name?
Your Lordship, Kajal Malik.
Hmm.
Even though name was listed in the first list, I was selected, but at the time of the
He said that you were absent.
Yes, Your Lordship, at the time of the document verification, due to my ill health, I have also provided the medical certificate, Your Lordship, in page number 47, Your Lordship. Due to my ill health, my father submitted the original documents before the Your Lordship, before the CTPO, Your Lordship. Thereafter, they have remarked me as absent and did not select me, whereas the OP number 5, Snehalata Malik, she was selected, even though she was not eligible and she secured less mark than me, but I was not selected, Your Lordship.
So file an appeal. आपको कराइए.
Your Lordship, already appeal have been filed.
Oh, appeal you have filed.
Your Lordship,
Very good, very good. What happened?
in Annexure 15, its first appeal, there it has been rejected by saying that though I was absent at the time of document verification, Your Lordship, so it was disposed of by saying that there is no illegality in that order which was passed by the CTPO, and
No, they say, or factually they say, further the appellant claims that her father submitted a written prayer on 11/8 allowing 7 days time to appear before the but the proceeding copy there is no mention of it. Moreover, the CDPO Dampada in her PwC mentioned that no such prayer has been received from the father of the appellant. Also, the appellant failed to produce or submit any received copy of the same prayer duly acknowledged by him. The appellant claims to have submitted and she produced a medical certificate. You could not prove it, or
Lordship, I have given representation also with my medical certificate, Your Lordship, page 46, Annexure 12, Your Lordship.
No, don't go to that. Your case is because of ill health, you could not appear, for which your father went before the selection committee, submitted a representation asking for 7 days time. There is no proof that your father went there. There is no proof that he submitted a representation. There is nothing on record. So how will the collector?
Lordship, in Annexure 11, page 45, I have given the representation, Your Lordship, page 45.
No, this is the representation. That is the representation. Where is the proof that it was endorsed? How do we prove? How can this court find out that you had gone there? When the CDPO says that her father had not come. So, anyway, let us see the second appeal. What has happened? Second appeal at all.
It has been mentioned in page, Your Lordship, 82, Annexure 17. Here also it is mentioned.
Just.
Before the ADM.
ADM पकड़े. Second appeal कहाँ पकड़े?
ADM, Your Lordship.
Second appeal ADM. किमती?
First appeal is to sub-collector, Your Lordship.
15(3) बाहर करें. 15(3) गाइडलाइन बाहर करो. ठीक हो सर. किमती हो? RDC पकड़ा हुआ कहता है. You have the ताकुत. Her claim is that her father went with a representation seeking time. The CDPO or what? Yes, Mr. Das. If they did not accept it and he returned home, then how it is to be accepted that he had gone to the selection committee? Very difficult.
Here the language is, the sub-collector will be the first appellate authority for hearing complaints against selection, disengagement of Anganwadi helpers for all projects. Any person aggrieved by the decision of the sub-collector may appeal to the district of the concerned district as the second appellate authority.
We'll accept it or
In case of helper.
This is a helper.
Yes, sir.
Yes. Yes. Yeah, purely factual aspect. Both the courts below have held against you. Nothing. You are only making an allegation. That allegation, how can it be proved when both the courts below did not find anything wrong in the selection process?
But
Meeting.
but your lordship have given medical certificate.
No. There is no proof that you have given medical certificate.
Yes, your lordship in page 47. in
Page
the
47 is the
representation.
copy which you claim to have served. That is not the proof that you have served it.
Even lordship have served, they have not accepted.
So you should have immediately come to the higher authority saying that they are not accepting my representation. Or you could have sent it by post. You have done nothing. And you ask the High Court to believe. Pawan. Come on. No, the petitioner. I am dictating the order.
Lordship, one more chance, your
No,
lordship.
no, this will not change because this is the matter. You are not prepared? Yes, I am willing to grant you another opportunity. But here, even if you prepare for years together, nothing will happen. Fact remains that you are absent. That you are not denying. You are admitting that you were absent because of your ill health. Somebody was sent, your father went there with a representation asking for 7 days time. There's no proof that your father had gone there. There's nothing on record. And if according your father's representation was not accepted, then immediately it should have been sent by registered post or through some other means or appearing before the higher authority by complaining before the sub-collector. Nothing has been done. So how? And this is the case found by the first appellate authority as well as the second appellate authority. Now this is a purely factual aspect. How can the High Court?
One more chance, I'll take instruction also regarding whether it was given through post also. Only one more.
No, you have not said that. You cannot improve upon your case. You have nowhere said. I've read your entire appeal memo also. Nowhere you have said that it was sent by post or any other means. You simply said that they did not accept. That also you don't say. The CDP or Dampada submitted that no such representation has been filed. So this is a purely factual aspect. Because of your ill health, nothing can be done about it. Yes, Mr. Das?
If she wants time for further preparation later.
All right, let's this matter tomorrow. Let's wait for.
Item number 12.
May I please? Matter relating to selection of Sikha child. And your lordship has already dealt with that the impugned order, very same impugned order in Madan Gopal Nandi's case.
मोरा मन अच्छे आगे को मदन गोपाल नंदी किए आज्ञा अक्षांश नंदी किए मुझे उड़े सब इतने जानी ची.
And the petitioner was one of the applicant. In the impugned order, your lordship will find from page and annexure 10 page.
No, let the state take.
अच्छी तानाटा अच्छी 63 रे तानाट.
इतने.
हाँ क्या. Page 63 रे. More read petition. Read petition रे 63 रे. Very same impugn, same impugn. 16 9 21 टा अपन.
He said, "Kon is what is the matter? Tell me."
relating to selection of शिक्षा सहाय
Yes.
मतलब ଯାଇଥିଲେ ସେ ଯୋଉ ରିଟ୍ ଅପିଲ ହେଇଥିଲା
You are Madan Gopal Nandi. Oh.
ନା ନା ସେଥିରେ ମୁଁ
No, what is
ହଉଛି
your name?
କାମିନୀ ଆଚାର୍ଯ୍ୟ
Huh?
ମୁଁ କାମିନୀ ଆଚାର୍ଯ୍ୟ
No, but the earlier 4 writ applications were filed. I have referred to them in that this
Yes,
tabular
yes.
form.
ମୋର ବି ଅଛି ମୋର ବି ଥିଲା ଏଇ
କୋଉଥିରେ? ଆପଣଙ୍କର କେତେ ରିପିଟିସନ ନମ୍ବର କେତେ?
I have stated in my writ petition paragraph.
You in the last occasion also, I did all the, I took all the trouble of preparing. You are not presented the facts in a facts cogently at all. इतने confusing facts आपको previous case कौन file करते ले ये जो table टा कौन आपने चेक करते ले
तापर डॉक्यूमेंट दे हला टू बी मेंशन ना
सेतल को ये जजमेंट सरला अपन डॉक्यूमेंट दला बिल इतने confusion कौन
प्रथमे से माने रिट रे आसिले
See, you were से जो बबीता शतपथी
आगे
अपन शेड को पळेले I remember से पे टू बी मेंशन रे तो पानी
आगे
No, let the state counsel go through whether this is covered by this, then I can pass that on.
So order नरे ता
हाँ देखिए दो General counsel of the petitioner submits that the case of the petitioner is covered by the judgment of this court in कौन से
Madan
Gopal Nandi
and
others. Number टा लिख दो है ना? Let a copy of the judgment
already
has been served upon the state counsel, who shall examine the matter and apprise the court accordingly. List this matter next week.
Fine. Okay.
Item number 13, pattern matter.
Between that matter, Sikha Sahayat,
Yes.
engagement of Sikha Sahayat, notification 2014, she applied and draft list was also published. Her name was found placed. She has opted for Puri, first preference Puri, and fourth preference Bhadrak. She was given fourth preference at Bhadrak, where there was no post. At the time of my lord advertisement, she had appeared in the B.Ed examination. The result was not published by that time, but she has given an undertaking that she will file the certificate on getting the result. My lord, your lordship, she has given the undertaking on 11/11/14. The date of submission of B.Ed certificate was 12/2/16. By that time, selection was not done. But she has never been appointed thereafter, so she approached this honorable. Last time, your lordship wanted to know whether there is any vacancy or not. There is large number of vacancies.
But what order can be passed?
My lord, right now, because I have been selected, so I should be given, because of their latches, why should I suffer?
No, that is true. That is true. Yes, Mr. Patnaik.
Yes.
What can be done?
So it is the story from the petitioner, my lord. So may I present the
Will
case?
you give a counter story?
That is what, my lord, now it is required, my lord, in this case.
Go on.
My lord, the grievance of the petitioner is that, my lord, she should have been adjusted being a SC candidate against the plus 3, that language plus 3 arts TGT course. Now, my lord, in order to be eligible for plus 3 arts TGT, that is a prayer, my lord. A person, he must have the certificate course of the BEd, my lord. Now, admittedly, this petitioner, though, had applied for the said post, but had not that particular requisite qualification as on the date of the application, submission of the application, my lord. Now, that is what we have stated in our counter, saying that the petitioner neither submitted the B.Ed pass certificate nor
Where are you reading from?
My lord, it is page number 2, page number 1 from the page number 1 of my counter, my lord.
Counter by opposite party number 4.
4, my lord. Yes. Para number 4, my lord.
Yes. Please,
that it is humbly and respectfully submitted that petitioner Kalyani Shetty had applied for the post of Sikha Sahayat during online application number so as plus 3 on trend under scheduled caste category as per advertisement published by the Government School Mass Education Department 2014-15. That the petitioner neither submitted the B.Ed pass certificate nor filled up the said column in her application. As a result, she was treated as plus 3 arts on trend candidate, and she secured 86.3690% mark without training qualification. that as per the instruction of the government assembly as well as OPEPA.
But come to paragraph 4 again.
Yes.
She had applied as an untrained candidate.
Yes. Now she is claiming that my lord TGT arts.
Facts. Then let us.
Then, madam. As per the instruction of the government SME department as well as OPEPA of Bhubaneswar, the date of verification of the testimonial certificates was fixed on 29/10/2014. Those who have opted first preference district as Puri. That at the time of verification, it was found that the petition Kalyan City had appeared the B.Ed examination under Jammu University. She was submitted an undertaking at the time of verification that now she is continuing B.Ed course in Jammu University and the examination already finished, but result will be published very soon. After publication of the result, she shall produce B.Ed certificate. That it is pertinent to mention that there was no instruction to accept such type of undertaking, either in advertisement or in resolution dated 6/8/2013. So it could not be considered. That government and SME department advertised 61 number of Shiksha Sahayak posts in +3 arts trained category for Puri Revenue District. As per the ORB Act, out of which 7 number of posts reserved for SC open category and 3 number of posts SC open and female, that post is 10, out of which 30% of 33% of female हिसाब रे और मेल हिसाब रे सेटा को advertise vacancy रे open और year election female. That as per merit, 7 number of SC open and 3 number of SC female having training qualification candidate was placed in the merit list, and the cutoff mark was 181.617 in SC open category, and the cutoff mark was 149.669% in SC female category, 10th category. Accordingly, after verification of the testimonial, the DPO SSA Puri, the engagement order were issued to such candidates by office order number 12/1/2005. 15. That after issuing engagement order, one Surekha Bala Behera from SC female category during application order not joined in her post, as a result of which said post was lying vacant. After that said post, vacant post was already filled up by one Krishna Priya Jali during application number 260304, who was placed in merit list as SC female untrained category of the said merit list by office order number 639, that is 24/2/2015, and she secured 158.931% mark. That the petitioner Kalyan City has secured less percentage of mark than that of the untrained candidate Krishna Priya Jali. For better appreciation of the Honorable Court, the copy of the selection, second phase of the first preference of the Puri Krishna Priya Jali is unlisted. So, my submission in this case, it is the stand of the opposite party, my lord, in this case, that the prayer what it has been made and the narrative, my lord, because it was previously presented, today it has not been, that after issuing the advertisement and after considering the cases of the different persons, thereafter taking into consideration the order of the Honorable Court, there was a corrigendum, or there was another extension of the time, my lord, for inviting the applications of the overage candidates. Now, the petitioner has made an allegation in this late petition, my lord, saying that then she would have been in a position to apply for the said post along with the trained certificate. That is why her case is to be considered under the +3 TGT arts category, which is not permissible. That is what we have stated, and we have given a reply, my lord. Now, with respect to her preferences and with respect to her position, so for Puri district is concerned, my lord, not a single person securing less mark in the whose name found place in that particular select list has been appointed. Now, when the authorities consider the case of the petitioner in the other districts as per her preference, then her position was, that is in para number 14, my lord, we have stated that in respect to this said corrigendum, OPEPA upload the eligible list those who had applied for the post of Sikashok in 4th preference district Puri and 1st preference overage candidates for the year 2014-15. Total 92 of plus 3 are trained on-trained candidate list downloaded from the paper. That is with respect to the second minor. The revised list after the, your lordship had already dealt in the previous other cases. After the overage candidates, a revised list taking into consideration the fourth preference vis-a-vis the 1st preference of the category. There,
No, that will be different.
no, that is why, my lord, we have
In that case, they were already engaged.
yes, my lord.
The question whether they will be thrown out of employment or not, that decision was never taken by the government.
Yes.
That is what I protected
Yes, ma'am.
them.
So, my lord, now here, as the petitioner opted her 4th option in Bhadrak district, so the name of the petitioner might have been placed in the eligible list of Bhadrak district for 4th preference, because this was filed by the DPC Puri, my lord. So, in Puri district, my lord, there was no vacancy with respect to this 2014-15, and whatever the vacancies were notified and the category to which the petitioner belongs to, that those particular posts have been already filled out.
What about Bhadrak?
No post. Bhadrak.
You are saying that some posts are lying vacant now?
No, that is in
Post are
Puri
lying
district.
at Puri.
As on date, the vacancies which are there, my lord, in the regular vacancy due to promotion or due to retirement or other things, my lord. These are the vacancies which the information of which, my lord, it has been collected to RTI and it has been presented for lordship. And on the last occasion also, we have clarified that particular position, saying that these are the vacancies. We have stated so, and that is not disputed.
So how do you respond,
My
Mr.
lord, no need, your lordship, I have responded to in my rejoinder. Your lordship may kindly turn to my rejoinder.
Rejoinder also they have replied. Anyway, what is the rejoinder?
Rejoinder, my lord, one Gunaniti Bhoi was given appointment who has secured less than mark than.
No, yes, I had asked you to clarify. This, I think you have given a reply.
Yes, ma'am.
They have taken the plea that pursuant to the second rejoinder, he was overage and he has been adjusted there. But I am the fresh candidate, I have not been appointed, but he has given appointment. And at Bhadrak, no post was lying vacant, so I couldn't get any engagement there also. Although I am having the qualification and I have been selected, I have not been given an engagement till date.
No, there is.
And another factor, my lord, they have given appointment to the untrained candidates, assuming that by that time I was not having the training qualification.
It could have been appointed as an untrained candidate also.
My lord, that is what, my lord, we have not rejected her case as an untrained candidate. Rather, we have stated, my lord, that the persons who have been appointed or who have been engaged in the untrained and trained category.
That is
Collectively,
right.
my
I've
lord,
seen
that is what, and she has secured less mark in comparison to them.
So what about Gunanidhi?
That is what, my lord, RA number 14, with comparing with the 4th preference district vis-a-vis the 1st of the overage candidates. There, when the case of the person, my lord, could be considered against the Puri post, Puri district, my lord. At that particular point of time, my lord, Gunanidhi case could come into picture, whereas the petitioner's 4th preference was for the Bhadrak district. And my lord, the grievance of the petitioner that because of the order of the Honorable Court.
I am nowhere. My lord, as per the first advertisement, I should have given an appointment. I was selected, but I have not given any appointment. Thereafter, corrigendum was issued by virtue of the direction of this Honorable Court to give preference, to give also
Opportunity.
some opportunity to the
Overage
candidate. So they have been engaged. Although I have been selected and I have been issued with some late engagement letter, I have not been engaged as on date.
All right, I'm closing it.
Yes,
I'm closing it. Yes. Hearing concluded, judgment reserved.
Number 40.
Oh, please.
Over on the last day.
Yes,
My
sir.
friend was.
On the last occasion, I was directed to take the instruction from the Osaka authorities. Here the case is that matter, the petitioners, petition.
Yeah, let me just go through the previous order.
Yes.
He sought for instructions from OPEPA and is now the case. Last chance is given to E.
Yes.
What was the instruction?
Case, recruitment was conducted by the School and Mass Management Department for the post.
Oh, that SCST.
Yes,
Oh, yes, yes.
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 So, my lord, even though, my lord, in written form, I have not received anything in addition to that. But over telephone, my lord, after contacting them, I got the information, my lord, the stand what we had taken in the previous occasion. And the authorities' decision rejecting the representation in the first round litigation, my lord. They are confirming the same. The stand is that, my lord.
We have given an undertaking. That is the only one.
Undertaking. After the first phase selection was over, when the petitioner, like the other persons, my lord, there are different, many others, they could not figure within that first phase list. And the coming of the second phase list was uncertain. At that particular point of time, one option was asked for. It was called for. It was not that they had to exercise the undertaking under compulsion. Knowing it very well that there is a very limited chance, at least to get to in the second phase or not. So they opted through their undertaking that we are willing to join in the ST and SC development department, and we have given that undertaking or something. And we will not claim in future against the post meant for the school mass education department. So, my lord, that is this. When they knew it, my lord, there was a decision of the among the authorities.
That's all right.
That the ST and SC development department, they have also the same.
I get the point. Now, under such circumstances, Mr. Das, whether estoppel can be raised against the state government?
Yes. If the advertisement is under a particular statute or particular department, really because somebody either option or no option, that will not come in the way. Moreover, when the second and third phase selected, if there is no second, third phase selection, then it would have been otherwise. All other are junior to us. In junior, in the sense, my lord, in the merit, they're junior to us. So they have been allowed to continue here. So no further option was asked for. Yes, there are vacancies. Do you want to come back to your parent organization? That was not the requirement. So therefore, my response submission is there cannot be an estoppel against this. And once the advertisement has been issued in a particular manner, it is to be done in the manner it is. And there, because we are the, we may say, at the relevant time unemployed persons. In dearth of employment, they choose, yes, they say, you go, we go. That doesn't mean that will be used as a estoppel against us. And moreover, this case I am fighting out from 15. The day I have joined there, immediately I have raised this objection when the second phase election was. They could have brought us back. Because the first round direction was to consider our case. That was rejected. This is section.
SN Patnaik Leonard AGA submits that no written instructions have been obtained from OPEPA, but he has been verbally instructed to reiterate the stand
taken in the count.
Already taken in the counter.
Impugn order.
So also in the impugn order.
The counter is the counter justify the counter.
That is what I was justifying.
Shikha Sahib, the repension only the rejected on the ground, sole ground, or that is the residential certificate. And the residential certificate is not a disqualification. As for the Chandramani Janas case, my lordship, I have submitted before lordship. Only my learned state council submitted that is on a new point raised that the SCBC certificate rejected. But I have also filed an additional affidavit. SCBC certificate also valid. I have already obtained the SCBC certificate is the result of the path. That is cannot be cancelled any time, my lord. This is the SCB certificate I have given.
No, let us see the impugned order. On what
Impugned
ground?
order only, they have not whispered about the rejection of the SCB.
So whatever they have said, that we will consider.
Only yes, your lordship see that is annex impugned order, that is the
It
annexed
only says that the case is related to the advertisement in the year 2006 and the process of engagement for the same advertisement has already been completed in the year 2007.
Yes.
There is no existing vacancy in the post of Sikha Sahayak presently in Simulia block.
Yes.
Moreover, the prayer of the petitioner for her engagement is
In the light of
under the ground of limitation.
in the light of the Shaktipada Mahapatra's case, your lordship, I have cited in the rejoinder, there is the same advertisement. He has come and also in the flux of time they have taken the ground that is the year after 1 year this is the selection list expired and we cannot consider. He is agitated before this honorable single judge.
You have a dead chart?
Yes, I have an this is the your lordship see. That is the appellate second judgment. First Chandramani Jana's
No. Do you have a dead chart?
dead chart.
Dead chart ताले टिके सुविधा हो देखिए आपने.
Dead chart हम करेंगे जब नोट नोट सा दे देंगे.
No, dead chart ताले argument करेंगे सुविधा हो. When was the you were an applicant in 2006?
2006.
Correct.
Yes.
So
I agitated. That is I was selected.
you were selected, but
Three.
serial number 3.
Three.
Yes.
SUC category. Thereafter, they gave the appointment to my juniors. They did not consider my case because that is my residential certificate. I belong to that is the nativity at Simulia, but my father-in-law's house is Soro. So pupil that is made a complaint that he does not belong to Simulia. So that's why the residential certificate rejected. At that time, many people came before the Honorable Court regarding that is challenging the residential certificate. And residential certificate, this is a Chandramani Jana's case. It was held that the residential certificate is not a disqualification for the engagement of Sikha Sahayak. This is Chandramani case. So this is squarely covered.
No, but now the representation appears to have been rejected mainly on the ground that it was of the year 2006.
May be permitted.
Yes.
Pen number 17, my lord, maybe Perus first. What your lordship now Perus, that is pen number 18. Pen number 17. The petitioner submits time and again, my lord, that other person they have approached before this honorable court, challenging that residential certificate, and that has been decided in Chandramani's case. But what happened in this case, my lord, with respect to the petitioner, your lordship may peruse the first para. The petitioner herself, my lord, she approached in the WPC number.
Which jagah page?
Yes. Well, at pen number 17.
Page 17 of the impugned order?
Yes. And answer 5, it starts with pen number 16 in my case.
Yes.
Which
paragraph are you reading?
From the top, my lord.
The
the petitioner filed, my lord, that was in the previous page. A read petition before this Honorable High Court in WPC number 2080 of 2007.
This is very relevant because he appeared in 2007.
That is what, my lord, I'm now making a submission, my lord. The Honorable High Court of Orissa in order dated 10/2/2009 passed the following order. Then the order portion has been quoted, my lord, to consider the representation. That pursuant to the above order.
No, it is made clear that the collector shall dispose of the representation only if any post of Swechasevi Sikha Sahayak is lying vacant in the block.
Now, my lord, now coming to the second one. That in pursuant to the above order, the Honorable High Court, the matter was heard and in this court on 10/8/2009 and was rejected by the order dated 10/8/2009. This order dated 10/8/2009 and WPC number 2080 of 2007. Lordship may peruse in the certificate also. That has not been reflected. And saying that omitting this particular person that she had previously approached in the year 2007 and her representation was considered and rejected in the year 2009, which she had never challenged. Now we are saying that, my lord, in the year 2021, it is very limited.
Your lordship come to penalty.
Now, so, my lord, this particular aspect, this is also available in the impugned order. So it is not only, my lord, the last para, that is the case, my lord, that what it has been presented before lordship in page number 18. That is not only the only para, but with respect to the ground of limitation and other things. That is not relating to the 2006 selection. That is with respect to the position, my lord, that the petitioner's grievance has already been adjudicated and decided by the competent authority complying your lordship's order, and it has been rejected. And in 2009, that order has not, neither that has been challenged at that relevant point of time, nor at this particular point of time given that. And thereafter, what happened? Some developments were there with respect to the residential certificate and other things in the year 2015-16. Then she submitted a fresh representation in the year 2018 to the government. Now, government directed the collector to consider that 2018 representation that has not been enclosed here. 2018 representation. And when that was not considered, then the petitioner approached before this honorable court in the just before round of litigation minor. And there he submitted, the petitioner submitted that since a representation has been forwarded and there is a direction of the government to consider the case by the collector, that collector to take a decision, and this is the outcome of that particular decision. But now it will be also relevant matter to verify that WPC number 13390 of 2021, whether the petitioner has disclosed this particular status of 2007 case, in that case at least or not. This matter may be called for reference matter. This WPC number 13390 of 2021.
13390.
No, I mean, next there is a order copy of the
order copy. I am praying before Lordship for calling for the record matter to verify that whether this particular fact has been suppressed or it has actually been presented before.
All right, let it come.
Point of that is
No, not on
legal
technical
point of view. That's what she should decide, because your Lordship that is annex of 3.
Yeah, all right, Mr. Ratha, let it come next week along with this.
Yes.
Your Lordship, see annex of 3, page 14. The government already there's a directive to the collector to consider the case of the petitioner.
No, Lordship,
see
that
that is
particular
annex
order.
of 3,
Yes,
page 14.
that is
the your Lordship, see.
in enclosing here with a copy of the representation dated 31/7/2018.
Everything. I have cited that is the
All right.
residential.
What further arguments in part, let this matter next week along with the WPC number 13390 of 2021.
Yes.
Regarding there is the residential ground, this is the improved order. This is the only ground of the residential. And
No,
at the
but the
application
limitation
time,
is-
All right.
now he is.
Sir, we'll take it up next week. Item 16, permitted to withdraw.
17.
Item 17.
16.
16 the withdrawal.
My appearance be recorded.
In this case, my lords have permitted me to file a rejoinder. Rejoinder has been drafted. As the petitioner is, I want 3-4 days time. Next week, any date, my lords will pick so that I will be able to file the rejoinder.
All right. Is this matter next week as requested by Sri J.K. Rathalan, Senior Counsel, as he intends to file a rejoinder? Yes.
18. Your lordship directed that affidavit has to be filed. It was yesterday's list and it was brought about today. One Akshay Kumar Sahu was said to have appeared and to your lordship directed that he is to file an affidavit indicating that the petitioner has expired in the meantime and his wife is receiving the family pension. To that extent,
He is also not appearing today.
Okay.
So I will go, but have you taken instructions whether the petition?
the number I had, I telephoned, I could not get in response. Once I get it, I can write to his wife.
No, the problem is we cannot pass an order in favor of a dead man.
If that is true.
I will record the absence of Mr. Sahu today also. I will adjourn it on the ground that you have to take instruction whether he is alive or dead.
Yes, ma'am.
All right.
That's it.
Learned Senior Counsel Sri J.K. Ratha is present for the petitioner. None appears for opposite party number 3 on repeated calls. Sri Ratha requests for some time to ascertain whether the petitioner is alive or not. List this matter.
25th September.
25th September? Now to your
Kind out is some longer time.
9th October.
9th October.
Kahin na taku mu tau date loku chicks ei pari meni tar permanent address ta nai seti sedi dei thanta se jo tar wife address ta dei thanta I could have contacted but
So 9th October.
9th October.
I don't know, 19.
19 is also yours.
Nice minus my name. Our name be deleted. It has been transferred.
The name of Sri Durgesh Narayan Ratha be deleted from the.
Bhavani Shankar Raiguri is appearing that bill has been transferred.
Yes.
My lord, on behalf of my senior, Mr. B.S. Regular, sir, kindly please 1 week time be given for filing date chart.
Date chart by?
Sir, actually, sir is held in another court. Kindly please.
Court upon sir is held up in another court. ସେଥିପାଇଁ pass over କରାଯିବ ନା ଡେଟ୍
Sir,
ପାଇଁ
date
ଆପଣ
chart ପାଇଁ 1
ଡେଟ୍
week.
ଚାର୍ଟ ପାଇଁ ଟାଇମ ଦିଆଯାଏନି ମୁଁ ଡେଟ୍ ଚାର୍ଟ ପାଇଁ ଆପଣ ରେଡି ଫାଇଲ ଧରିଛନ୍ତି ମାନେ ଡେଟ୍ ଚାର୍ଟ ରେଡି ହେଇଥିବା ଦରକାର ନହେଲେ ଫାଇଲ ଫେରେଇ ଦିଅନ୍ତୁ ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟକୁ ଆପଣ ଡେଟ୍ ଚାର୍ଟ ଯଦି କରିପାରୁନାହାନ୍ତି ତାମାନେ ଆପଣ ପ୍ରିପେୟାର କରୁନାହାନ୍ତି you have not prepared your case at all.
In this case, I am appearing on behalf of opposite panel of 5, my lord. I have filed counter affidavit and served to the government. But whether it is served to the petition or not, because
I am passing it over. Call him. Pass over.
20.
Item 20 के time में पूछ रहे थे. Yes, item 20. Somebody was asking for time in the morning. Yes.
Opposite party, they had to file counter, Your Worship.
Who's the petitioner?
Then for 1 week time.
Just a moment. Who's for the petitioner?
I am putting petition on behalf of Mr. Sambit Mara.
On the last occasion also they took time to file counter. And today, what is the problem?
With Mr. A.R. Mishra is suffering from fever.
It's all right. But what about your counter?
Well, in the meantime, I will file counter.
Prayer for adjournment is made on behalf of Mr. A. Mishra, learned counsel for the opposite party number 3 and 4.
As well as 5, 6, Your Worship.
As he is ill. Further, 1 week time is request. Check करते हैं. Please this matter. On 25th September, counter affidavit if any be filed in the meantime.
Interim order to consider.
It's a matter to consider.
Item 51.
Samir Kumar Das. Item 21, yes.
So, the two writ petitions available here. Actually, the first one is by the governing body of a school.
अपन मिस्टर सत्वती अपन छाड़ दें उसी जगह अपन जगह छाड़ अपन एपड़ yes you come there.
That's it.
That is the arguing counsel. क्या मरा ही नहीं क्या हमारे पछे पटे मरा ही नहीं ना मारो आजी मारो
Small list of dates.
Yes,
for
yes.
convenience.
You are appearing for whom?
I'm appearing for, in the second matter, I'm appearing for the petitioner,
Second
who's
matter.
the incumbent librarian.
Second matter what ଅଛି अच्छा हो governing body of उत्सव चरण गाजियानी चंडी college.
That's it.
You are the governing body.
That's it.
Yes.
The governing. So, Lordship,
Who's opposing you in this case?
Lordship, the then librarian who was subsequently terminated.
Who's appearing for him? Mr. Das? Oh, you are.
Telephone instruction disengage.
Just be disengaged. ताले वो infructuous है क्या? अब कौन करे जो? No. The termination was set aside and the petitioner has been directed to reinstate the opposite party number 3 into service. Then what happened? He was reinstated.
No, Your Lordship, I am for the governing body.
Yes, that
I am
is-
challenging that order.
Yes.
He said that the as in the termination was set aside on the ground of violation of natural justice. So my preliminary point is, of course, there are
That I will consider. Let me just understand the facts. Yes. What happened? He was disengaged and in an appeal, it was set aside and he was reinstated, directed to be reinstated. So challenging that order, they have come. अपना तो वापस करिए.
He had received 7,10,000. Today instruction, he will disengage.
Again, subsequently disengage. ना कौन?
से हमको disengage करो.
तो आपण को disengage करो. कौन 7 लाख कौन?
से receive करती.
आपण को disengage करिए. से. Then we'll have to issue notice again. Has he engaged anybody else? It is submitted. Your good name, sir. I'm forgetting always.
J.R. Dev.
No.
Prakash Kumar Behra.
Prakash Kumar, I'm sorry. The Prakash Kumar Behra, appearing on behalf of Sri Samir Kumar Das, submits that his client, opposite party number 3, has disengaged him as his lawyer in the case. Stop. It is not known whether any other person has been engaged by opposite party number 3. Office to verify and Office to verify. Stop. List this matter. Okay, next week, kore? No, that for a week.
25th September.
On 25th September.
Also, the interim order. Let it be continued.
What is your matter?
I'm the
Yeah.
librarian who is incumbent right now, in place of who, after his reinstatement, he was appointed. So I am a
So you
party.
were appointed in the termination vacancy.
After I was an assistant librarian. After he was terminated.
No, madam, you were appointed against the termination vacancy.
Gotcha.
You were an assistant librarian in the same college. So you were appointed in his place.
And I was not made a party to the appeal also. That
Why
we
should
are
you be made a party? That is between the employer and the employee. Why should you be made a party? What interim order has been passed in your favor?
on 10th December 2013, the interim order is of the nature that the order is stayed. The impugned order under Annexure 7 is stayed.
Impugned order under access from the same order. That order directing reinstatement of the petitioner that has been stayed. All right. Interim order to continue.
Grateful.
Item 22. Lord, sir, 22 is a matter relating to taking a direction to the opposite parties for approval of the post of the petitioner as headmaster of an UP school. It's a case of 2014 and the government filed a counter and stating inter alia that the appointment has been made without taking permission from the government, and my claim can be resolved under section 24B. Plus, I have filed the rejoinder. Plus, they have quoted impugned order is under Annexure 11. There they have quoted the provisions of 74 rules, which has been repealed. And there they say that they have referred to 1974 rule that is applicable to aided schools, aided institutions. I was appointed where the school has not been notified and the school was not an aided institution. And lords, the prior to this is dated 21/6/13 under Annexure 11. Prior to that, Annexure 9 and 10, both the annexures, the district inspector schools, they have recommended my case for approval and sought for certain documents to produce for consideration of my approval. Now, the present status is even 2022. They have the Lord's deputy director.
There is 74 rules.
Yes, 74 rules has no application.
No, that rule 5 which has been omitted, that is of 74 rules. But there is another rule.
5(1) sub rule 8(9) of recruitment.
8. Rule 8 will be applicable?
Applicable, Lord's kindly see.
B will be applicable. The vacancy in a post carrying higher scale of pay is filled up with prior approval of governor. Not for anything, if it shall not be necessary to apply for or to
Lord, this has no application because Lord, I humbly reiterate my submission that before the school came within the fold of 1974 rules, I have been appointed. Therefore, it has.
No, you were appointed, but you were appointed as headmaster.
Because somebody was appointed as an assistant teacher and continue as headmaster. Thereafter, I was appointed after his resignation.
Just let me just understand this. There's a proviso. In nothing it shall not be necessary to apply or submit an appointment made by the if the vacancy in a post carrying higher scale of pay is filled up with prior approval of government in case of a college and the concerned director in case of an institution other than a college by an employee of the same institution possesses the requirement experience and I have also had the occasion of rendering a judgment in this regard, interpreting these particular rules, where I have also held that the part appearing in sub-rule B, which is such appointment to concerned authority, this ought to have been placed under clause A. not under clause B.
Lords, I have no dispute or
Let us see.
quarrel over the application of the rules which your lordships.
Let us see. Let us go to your date chart or whatever dates, relevant dates, please. You were appointed in 1995. Okay,
2008. That is my appointment letter. Lordship kindly see page 18, Annexure 5.
yes.
23rd 4, 2008.
So the school managing committee reasons the following persons are appointed temporarily as headmaster.
Then I submitted my joining report on 24th.
No. What is your initial appointment? Is this as headmaster? No, initial appointment must be as assistant teacher or something like that.
Headmaster, it is written there. Headmaster. But it cannot be accepted as headmaster. He is to be.
There is no concept of direct appointment. Anyway, so we'll treat it as the assistant teacher.
Assistant teacher.
Then
your lordship kindly see, school was notified 24/4/2008 with effect from 1/5/2008. That is specifically mentioned in page 20. Your lordship kindly see, page 1st May 2008. So my appointment is much prior to the school as notified to be an. Thereafter, Lord, series of correspondence made by the district inspector of school to the authorities.
But here somebody else has been mentioned as the headmaster, Bimbadhara Behera.
Yes. After his resignation, I was appointed.
Lakshmi Priya Samotray.
Then, Annexure 9 is a letter by the district inspector of school to the secretary calling for certain records for approval. Then next page, next annexure is also like that. The district inspector of schools returned to the director for approval of my appointment. Thereafter, when the matter was subjugated, that was rejected on these grounds. Then your lordship kindly see, to their counter I have enclosed three documents. One document of the year 2021-22, that is a document named Unified District Information System for Education Plus. There they have admitted my appointment and continuance. Also, along with me, another assistant teacher. It is continuing like this up to 2022-23. Then, lordship kindly see, in the counter affidavit, they have suppressed the fact that the correspondence between the deputy director with the BO of their field authorities, that is of the year 5/4/10. There the district inspector schools written to the director elementary education for approval appointment of Snigdha Mahapatra and Master Shankar UP School so and so. He has written like that. Thereafter, the deputy director also written to BO approval of appointment of headmaster in non-government schools. So these are the conditions. He says, I am directed to invite a reference to government letter so and so on the subject cited above and to request you to verify teacher as per the list enclosed, where furnish a certificate to this effect that there are no more teachers involved in the concerned non-government UPME school as per your earlier proposal. Any further substitution vacant of teacher consequent of a resignation etc. to be reported to directorate within a week, submission saved to government as it is. So government wanted the teachers who are continuing as such for consideration of their case for approval. This is the total background of the case, and the counter they have stated this, that I have my appointment was made without seeking primary permission from the state and referring to the 1974. These are two grounds they have stated. Also stated that REIT is not maintainable because availability of provision section 24B. Your lordship kindly see, it is a case of 2014. In the meanwhile, these are the years we have consumed. And your lordship knows also our High Court division bench where the matter is ripened for hearing. And also 2004 Supreme Court Durga Enterprises Private Limited, their lordship says since the case is ripened for hearing, at that stage parties should not be relegated for availing the alternative. This is my summary.
All right, we'll take it up next week.
18 September.
Huh?
18 September.
heard in part, list this matter on 18th September. For reply by the state.
Item 23.
Lordship, I'm seeking an adjournment.
2005-15 matter. All right.
Shortage.
As requested by learned counsel for the petitioner, list this matter on 25th September.
Item 24. This matter relates to termination of Kamrojagar Seva. The notice has been issued and counter has been filed. During pendency of the repetition, when the authority went to appoint another person, Rishta Pradhan. Therefore, I have filed another repetition, WPC number 711 of 2018. Both the repetition may be tagged so that.
Yes, ma'am.
List this matter.
So now they are going to fill up the vacancy by
Next week,
press advertisement.
List this matter next week along with the WPC number
711 of 2018. Case number
711.
711 of 2018.
7711 of 2018. Yes.
This case is annex 2 to be the order.
Is it active?
Item 25.
In this case, the earlier order, there is 780/24 may kindly be seen. And the government is directed to file affidavit. So far as the appointment is concerned, by the annex of 5 minor.
Today I'm filing the affidavit. And I'm serving a copy of this.
What is your reply?
Previous, there is a direction to complete the selection process in terms of Annex 13.
Pursuant to advertisement enclosed to the rate application as Annex 13 within 6 months.
And that Annex 13 is Annex 1 in the present writ petition.
No, his grievance was that despite such order, a fresh notification was issued as per Annex 3-5 series. That is what his grievance is. So you were directed to obtain specific instruction as to whether the selection process was conducted in terms of the order passed by the coordinate bench in the previous rate application. So what is your reply?
Annex 13, Annex 1 in the present writ petition. The selection, I didn't find that that is in terms of that.
Annex of 5 may kindly see.
Yes, just
they have specifically stated that since the order to writ has been dismissed, so this notification has been issued. We mentioned there
no, earlier direction was to conclude the selection process.
Yes.
You were an applicant in that selection process. So instead of
prior to that, another notification. Thereafter, because that the present notification that is Annex 13.
You have to prepare a date chart then. Prepare a date chart. We'll take it up.
Today I have also sought a copy of the.
You take this counter and you have received a copy. Learned AGA files counter affidavit in the court after serving copy on the counsel for petitioner who wants some time to go through the same. List this matter. 25th September. On 25th September. September. Learned counsel for the petitioner is requested to be ready with a list of dates. Prepare a date chart.
Item 26.
So this is my seeking for an adjournment in item 26. Have you come up with another date?
Lordship may take up counter, agenda, everything is there. So after a long time, 2018 matter, the appointment as against the post of.
All right, list this matter tomorrow. List this matter tomorrow as requested by learned counsel for the opposite parties. Yes.
Item 27.
Not opposite party, she is seeking intervention. That has yet to be allowed.
You are an intervener.
Yes.
Who is for the opposite party in that case?
Intervention has not been allowed.
List this matter tomorrow. Item
27.
My pleasure. Here I have challenged the order of the appellate authority. Pursuant to a notice, my lord, I have applied for Anganwadi worker, my lord. Lordship, turn to page 22, my lord. Page 22. My name is serial number 3, my lord. I have secured 64% of mark.
Yes.
On the top one, 50% was selected, my lord. Against that, I filed an appeal, my lord, before the appellate authority. Appellate authority, although rejected the my lord, cancel the candidature of opposite party number 6, my lord, Daha Maji. But instead of giving appointment to me, my lord, he has directed for re-advertise for re-selection, my lord. Against that, I have approached before this present writ application is against that, my lord. And your lordship issue notice to opposite 6, my lord. And instead of filing counter, my lord, now I file a miscase at flag C, my lord.
Yes.
Now a fresh advertisement has been issued, my lord, in respect of that center.
All right. But has notice been served on the private opposite party?
Yes.
Let us see. ED received from opposite party number 6 after valid service. Yes. What about your counter?
I have not filed any counter. It is
The counter will be necessary in this case.
on the basis of the impugned order, my lord, only the grievance of the petitioner, my lord, that it has been considered by the authority, by the appellate authority. Only thing, whether the decision.
The next person should have been appointed.
My lord, that is what my lord we have stated. Now, if your lordship will come to the impugned, the order, my lord, of the appellate authority, there, the discrepancies and the wrongs committed by the authority while issuing the advertisement itself, which is not in conformity with the guideline of 25/2007, my lord. That has been taken into consideration, for which, my lord, a fresh advertisement is directly issued. Not only discarding the candidature of that particular person, but also taking into note of the fact that the advertisement was defective.
So instead of staying this, Mr. Das, you never know what will be the final order in this case. So you rather take liberty to participate without prejudice to your claim.
No, my lord, what has happened? He has stated, collector has stated that the clause 3 is defective, but so far as area is concerned.
That will be considered. That will be considered in this writ application, whether the impugned order is correct or not.
It is the ITD area. So the qualification 8, rightly has pointed out in affidavit, in advertisement manner. He has stated it should have been matriculate, and in ITD area, it should be 8. Now it is an ITD area.
No, I'm not on merits of the case. I can consider, if you are ready also, I can finally hear it. I'm not on that. The problem is, if I stay the advertisement and debar you from appearing in that advertisement.
Now I'm continuing.
You were selected.
No, I am not selected.
Then how could you continue?
I am in charge of that center.
How? On what basis?
Yes, annexure, because page annexure 10, page 7 of that miscase. Earlier, OP number 6 was continuing. By virtue of collector's order, she was. ଏତଦ୍ୱାରା ତଳପଡ଼ିକା ଦହମାଇ ମଝି ଜଣାଯାଉଛି ଯେ ଜିଲ୍ଲାପାଳଙ୍କ ସଂଘ ଅନୁସାରେ ତାଙ୍କୁ ବହିଷ୍କାର କରାଗଲା. And there next page. I am working in another Anganwadi center, which is far away from my village. At that time, my village was not coming under, no Anganwadi center was created. When it was created, I applied for the same, taking permission. Now, ଏତଦ୍ୱାରା ଆପଣ ଜଣାଇ ତଳପଡ଼ିକାର ଅଙ୍ଗନୱାଡି ସେଣ୍ଟର ଅଧୀନରେ ଥିବା ଶ୍ରୀମତୀ ଦନାଇ ମାଝୀ ପ୍ରସିଦ୍ଧ ହେତୁ ତଳପଡ଼ିକା ଶ୍ରୀମତୀ ରାଜେଶ୍ୱରୀ ନାୟକ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଅଙ୍ଗନୱାଡି କର୍ମୀ ସିପି ଯୋଡିକୁ ଦିଆଗଲା. ଏଣୁ ଆଜି ଦିନଠାରୁ ସେହି କେନ୍ଦ୍ରର ପ୍ରତ୍ୟେକ କାର୍ଯ୍ୟକ୍ରମ ଶ୍ରୀ ରାଜେଶ୍ୱରୀ ନାୟକ ସୁଚାରୁ ରୂପେ ତୁଲାଇବ.
No, but if you are already working as an Anganwadi worker in one particular center,
which is far away, yes, and I have stated
is it permissible?
Yes, there is no bar in the.
I don't know.
Because that is far away from my village. At that time, in my village, there was no Anganwadi center.
No.
So I am bound to apply the.
But that has never been challenged, so we will not get into that. But being a Anganwadi already engaged as an Anganwadi worker, whether it is open to her to compete here, we find out.
With respect to the disqualification, my lord, such a provision is not available in that.
No, may not be there. If it is not there, we cannot read that into the statute.
Because her case was actually entertained even by the appellate authority while entertaining that Anganwadi appeal.
Yes.
And on the basis of that appeal only, the selected candidate's appointment was she was disengaged. But as it has been pointed out, when she is enjoying one post,
I will not state. I am right away. I will only say that any selection made shall abide by the result of this writ application. 11154 of 2024. It is stated that an advertisement has been issued for engagement of Anganwadi worker in respect of the center in question.
State counsel.
No. In this case, my lord, I think my lord, Chittaranjan Malik tha?
Okay.
So, on 10/9/2024, my lord, the counter has been filed, my lord, and I'm serving the copy.
Court file any? Court copy?
He filed on 10/9, but hard copy is also.
File the hard copy.
Yes, ma'am, just now.
The AGA files a physical copy of the counter, e-file earlier. Copy of the counter has also been served upon learned counsel for the petitioner. Is this matter
7th October.
on 7th October? Rejoinder, if any, be filed in the meantime.
It was 29.
Last copy of your order dated 21/11/2023. Hence, State Council extension for time extension comply the order dated 10/10/2023. Not complied.
Okay.
What is that order?
But
Achha. My lord,
There was a inquiry was directed to be conducted by the secretary.
yes, madam. And
Where's the report?
I think my lord, that has already been. Yes. Achha, yes. Submission of inquiry report by the principal secretary. My lord, that copy has been provided to us on 31/7/2024.
File it.
We'll file it, madam.
Learned AG submits that as directed by this court.
Yes.
Inquiry was conducted by the principal secretary, W&CD department.
Yes.
And the report is available with him. He wants to file the same
Within the course of it.
in course of the day. Yes.
Yes, I will serve a copy also.
After serving copy on the other
Yes.
side. Is this matter?
What I beg to say that in this case matter, I am appearing to the opposite panel 5. See, in fact, the inquiry report was called for the subsequent advertisement made regarding the irregularity committed in the office of the sub-collector, my lord. So far my case is concerned, I have been selected pursuant to the first advertisement, and I was continuing. After being selected, I was continuing in the center, and that order has been stayed. That is my whole grievance, my lord, because of
Short date for the. Short date for the.
not been selected.
15th September.
25th September. Is this matter on 25th September?
Item 30.
Copy the leaves.
Yeah, please, your lords. Matter relating to promotion of GRS to the post of Panchayat Executive Officer, my. This is second round writ application. In the first round writ application, this honorable court directed to consider my representation. After considering my representation, the Office 2 rejected my representation. Simply kindly see the page, annexure 6, page 37. My impugn. Kindly see page 38. Simply they have rejected on the ground that, and whereas a new rule, Orissa Panchayat Executive Officer Service, method such and such, bearing a server number such and such, dated such and such, published in the Orissa Gazette, came into force, and there is no such provision for filling of the post of PEO by way of selection from the Gram Rojgar Sevak. As such, there is no scope of selection from the Gram Rojgar Sevak to the post of Panchayat Executive Officer. My lord, kindly see my first order of first writ application, my lord. Order dated page 6, my lord.
Page 6.
Yes, my lord. 18/3/2021. Separate new rule asi nathila. Thereafter, they have not considered my representation. Thereafter, I filed a contempt. Page 7. Order dated 23/7/21. ସେତେବେଳକୁ ନ୍ୟୁ ରୁଲ୍ ବି ଆସିନଥିଲା।
Thereafter, they have not considered my contempt, this is called. Order of the first contempt, thereafter we filed a second contempt, ତାପରେ ସେ new rule ଆସିଛି ବୋଲି କହିକି reject କରିଲେ, my lord. Kindly my case, my lord. As per new provision laid down under Rule 2 of Odisha Village Level Workers Recruitment and Consumer Service Amendment Rules 2013, 30% vacancy shall be filled up by way of selection from the Rojuka Sabha.
Wait. Point of law here is when a dispute is pending and in the interregnum the rule changes,
My lord.
what will be the effect of it? What research have you made in this regard?
My lord, ମୋର ଯେତେବେଳେ selection ହେଇଥିଲା ସେତେବେଳେ old rule ଥିଲା ଫାଷ୍ଟ
ଆଉ ଥରେ କହିବି ଓଡ଼ିଆରେ କହିବି ଆପଣ ବୁଝିପାରିଲେନି ସେଥିପାଇଁ କହିବି
My lord.
ଯଦି ଗୋଟିଏ ସ୍ଥିତାବସ୍ଥା ଯେତେବେଳେ ଆପଣ ଗୋଟିଏ dispute raise କରିଛନ୍ତି ସେ dispute ଟି pending ଅଛି at different level either at the government level or at the High Court or wherever
My lord.
ସେଇ ସମୟରେ rule ଟିର ପରିବର୍ତ୍ତନ ହେଲା
My lord.
ଏବଂ ଆପଣଙ୍କର rule ଟା ପରିବର୍ତ୍ତନ ହେଇଥିବାରୁ ନୂଆ rule ରେ ଯେହେତୁ ଏଇଭଳି କୌଣସି ପ୍ରୋଭିଧାନ ନାହିଁ ତେଣୁ ଆପଣଙ୍କ କେସ୍ ଟାକୁ ରିଜେକ୍ଟ କରିଦେଲା ଏଠି ପଏଣ୍ଟ ଅଫ ଲ ଟା କଣ ରିସର୍ଚ୍ଚ କରିଛନ୍ତି ରାଇଟରେ which law will apply?
This is retrospective effect.
I don't know I'm asking you. You should have, it is your case, you should have prepared. So I'm giving you a hint. When the dispute was raised much prior to coming into force of the rules and it was pending before the authority, subsequently another rule came. Yes, Mr. Patnaik.
Yes.
This is the point.
Yes.
And the person who has passed that order is absolutely brilliant in service matters in the government, Mr. G. Patra.
Annexure 6, my lord.
And I'm sure he knows the law.
Well, Annexure 6, my lord, and thereafter, once again, your lordship directed to take the instruction. And on the basis of the same, my lord, on 20th January 2023, we have also got the same instruction.
My lord, kindly see
what it is.
ଆପଣ ମୋତେ ପଢିନା research କଣ କରିଛନ୍ତି?
Next week.
Have you examined any judgments? Point ଟାକୁ clarify କରିକି ଆପଣ କହିପାରିବେ ଏଇ point ଉପରେ ଖୋଜନ୍ତୁ.
My lord.
Fact ମୁଁ ବୁଝିଗଲି. Whatever you have stated about the facts, all right. You have done well. In the earlier rule, there was a provision for 30% of Gram Rojugar Sevaks will be considered for promotion. So that quota, 30% quota was there. That rule is not there. That provision is not there in the new rule. But your cause of action arose much before.
My lord.
In the meantime, when your case was being considered, so now the court has to look at two things. First is whether the non-consideration of the petitioner's case under the old rules. Why was it not considered? It can only be considered. There can be no mandamus directing him to promote. Can there be?
My lord, that is what, my lord, in the subsequent clarification, when your lordship asked, then that has been clarified. His case was considered. But taking into consideration the number of vacancies which are available as on that particular date, his position was 32,
Yes,
whereas vacancies were 31.
31.
Then one of the person from among these 31.
Have I heard this matter earlier also?
My lord.
Yes.
Many times, my lord.
Oh, yes, I've heard it.
My lord,
In January 2023, I've passed a C. Yes.
Order
No. In course of hearing, Mr. R.N. Mishra, Learned AGA submits that as per instructions received, the gradation list referred to by the petitioner has since been changed. Inasmuch as one Jagannath Parikh having approached this court, challenging his position in the gradation list, was placed at serial number 9. As such, the petitioner's position was changed to 33 instead of 32.
Yes.
Let a copy of the instructions be
I think,
served.
my lord, then your lordship have already taken note of that particular instruction what we have
Yes.
received. That is 20th January 2023.
Yes, my lord.
So, my lord, the position is like this, my lord. Your lordship.
So it was considered, but he was not found suitable.
No.
There were no vacancies.
There were no vacancies.
Out of that
Now,
30% quota.
as against the 31, only one person didn't join, my lord.
So this
he was
Jagannath,
the 32.
this Jagannath gentleman joined.
No, Anil Kumar Rana.
No.
That Ashok Kumar Rana.
Ashok Kumar Rana.
Okay.
He didn't join. He was within this 31. So the petitioner's case ought to have been considered because now if 31 posts are required to be filled up, then petitioner number is the 31. But later to that, my lord, complying the direction of this honorable court, when we consider the case of another person and he was to be properly placed in his position, then he figured within the 31 above the petitioner. Then once again, in total, including Ashok Kumar Rana, the position of the petitioner became 33, and excluding Ashok Kumar Rana, his position is 32. And my lord, the posts were 31. So the right of consideration has not been denied, but at the time of taking
Because the want of vacancies. Want of vacancies.
that is what, my lord. They have
What can be
stated.
done?
My lord, kindly see my additional affidavit, my lord. I filed an additional affidavit. ସେମାନେ ଜଗନ୍ନାଥ ବାରିକଙ୍କର କେସ୍ କୁ କନସିଡର କରି ତାର ସିରିୟଲ ନମ୍ବର 9 କୁ ଆଣିଲେ ସେଠୁ ସେ ଗ୍ରେଡେସନ ଲିଷ୍ଟ ରେ ମୋ ସିରିୟଲ ହେଇଗଲା 33 and see the that gradation list, my lord.
Where is it?
Additional affidavit page 9 and 10, my lord.
Additional affidavit, page 9 and 10.
My lord, ସେଥିରେ ମୋ ସିରିୟଲ ନମ୍ବର ପଳେଇଲା 33 page 10.
Yes.
Yes, my lord. Kindly see the page 10.
You are Umesh Kumar Das.
Yes, my lord.
Yes.
31 ଜଣ fill up ହବା କଥା ମୋ ସିରିୟଲ ରହିଲା 33. That place, my lord, page 10.
So you don't dispute that the number of posts were 31.
31.
Yes, well, you're at 33. Then
My lord, kindly that page 10. Kindly see the serial number 21.
21 is Jayant Kumar Barik.
Last two legacy unauthorizedly absent since long.
Yes.
Then
Ashok Kumar Rana, absconded since 16 months. So
But
there are
my
two vacancies. One Jagannath has been filled. 2 vacancies are 31 ହେଇଗଲା.
ଜଗନ୍ନାଥ ଆଡ ହେଲା ପରେ 33 ହେଲା, ଏଇ ଦି ଜଣ ବାଦ ପଡିଲେ ମୋର 31 ହେଇଯିବ.
Yes.
I have to get the instruction with respect to Jayant Kumar Barik whether he has been extended with the benefit of promotion or not.
Because unauthorizedly absent since long ଲେଖା ହେଇଛି.
Consider.
Yes, my lord.
That's how heard in part. In course of hearing, attention of this court is drawn to the revised final gradation list of GRS as on 27/7/2020, wherein one Jayant Kumar Barik,
ଜଗନ୍ନାଥ ବାରିକ.
no, ରୁହନ୍ତୁ ଆଗେ. One Jayant Kumar Barik, who is placed at serial number 21, has been shown to be unauthorizedly absent since long. Further, one Ashok Kumar Rana, at serial number 31, is shown to have absconded since the last 16 months. Stop. It is therefore submitted by the petitioner that the vacancies being 31, and he being placed at serial number 33 is therefore can therefore be considered against one of the available posts, as one of such posts has been filled up by another person named Jagannath, namely Jagannath Barik. No,
Jagannath Barik.
Jagannath Barik. The State Council shall take specific instructions in this regard and apprise the court accordingly. List this matter on 25th September. Then they are.
My lord.
Yes. And the other part also you consider
My lord.
the effect of change of the rule.
My lord, my lord, my lord.
Yes.
And another legal point, my lord. I'm not opposing this. Promotion is not a matter of right.
Consider
No person junior to him has been promoted. That is
No, but on factual aspects, if he can prove that se ju di jana loko gale tabi to janu ko apna apna korche agote vacancy roila, then he could have been considered.
31 ଭିତରେ ରହିଲେ
31 ଭିତରେ ତ ରହିବ.
31 ଭିତରେ ରହିଲେ ପାଇଯିବା କଥା।
ହେଇଯିବ ତ। ସେଠି ମୋ କେସ୍ ବି କନସିଡର କରିବେ ବୋଲି କହିଛନ୍ତି.
देखिए yes, item 31.
My lord, entry mode to continue.
List this matter kebu kole 25th September interim order to continue.
Appellate matter.
31.
This matter, my lord, I'm filing the regional draft today, my lord. So, copy.
Sri Satpathy Learned Counsel for the petition of files rejoined. Are you filing it in the court? Files rejoined affidavit in the court after serving copy in the State Council. List this matter on 7th October.
Item 32. My lord, I have one prayer, my lord. My file petition, IA, my lord, 10457 of 24, my lord. Praying there in, my lord, for disbursement of area dues, my lord. Certain area dues is not disbursed.
See, then देखिए.
Final hearing to
Item 32.
32, may I please? Last occasion, my lordship directed the State Council to obtain instruction, also file the affidavit.
My lord, in this case, my lord, we have received a Parawise comment only on
Last time you have also
Yes.
said that.
But although, my lord, we have sent a letter, my lord, we have not yet received this. Our time there. At 2000.
Creation Patnaik Learned AGA requests for some more time to file the counter. List this matter of October. Karo. On 23rd October, counter will be filed in the meantime.
Right. Obliged.
33.
ଏଥିରେ ବି ଆମେ ଇଏ ଦେଇଛୁ letter issue କରିଛୁ for filing of the counter କିନ୍ତୁ we have not yet received.
Petitioner is not getting salary. Why they
Notices issued to opposite party number 5 and 6 have been delivered as evident from the postal tracking report. There is, however, no appearance. There was an interim order in your favor?
That is to give me salary.
Current salary,
That
yes.
Panchayat is, Sarpanch is a lady, my lord. So all district officials are even
So that's Subhadra.
fearing that to make a letter, talk to her or call to.
ଆମେ କଣ ଆପଣଙ୍କୁ fear କରୁଛୁ?
ନାଇଁ।
କି କଥା କହୁଛୁ?
My lord, frankly, my lord, the DPO said, my lord, honestly, we cannot call her, we cannot direct her. That to give, she is such a terror in that area, the lady, Sarpanch. That's why offline, not off the record, my lord, that's why he is not releasing my salary.
ସେମିତି କୁହନ୍ତୁ ଆମକୁ ବି ଡର ଲାଗିବ ପୁଣି ୱାରେଣ୍ଟ ପଠେଇଦେବା ୱାରେଣ୍ଟ ପଠେଇଦେବା ନନ୍ ବେଲେବୁଲ ୱାରେଣ୍ଟ ଅଫ ଆରେଷ୍ଟ ପଠେଇଦେବା
ସେଇଟା କଣ ମୁଁ ଜାଣିନି what would be the process, but that exactly that is the
ଅର୍ଡରଟା କମ୍ପ୍ଲେନ୍ କରିବେନି କଣ କରିବାକୁ ବାଧ୍ୟ ସେ ସିଡିପିଓ କରିବେନି କଣ
କହିବ ଆଜ୍ଞା ସେ ଗୋଟେ FIR ଦେଇଦେବେ being taking the gender as a tool
No, nothing of that. So whoever is a good administrator knows how to handle these people. Ladies of these nature.
ସେ ତ ଆଜ୍ଞା ବାଜିଯିବ ଟିଭି ଫିଭିରେ ସ୍କ୍ରଲିଂ ହେଇକି ଆଗ
କିଛି ସେ ଯାଏ ଯିବନି ଆଜ୍ଞା କଥା ସେ ଯାଏ କଥା ଯିବନି one has to handle it appropriately କଣ you cannot take that plea.
My lord,
କଣ ହେଲା
after taking the plea, my lord, I'm just taking some time, my lord, for filing of the counter.
All right. Learned State Council requests for some time to file counter. Leave this matter on 7th October, sir. 7th October. All right.
Do you want to continue?
Item 34.
This has been issued counter not.
Yes, ma'am. My lord, in this case, my lord, we have received a parawise comment that is only on 10/9/2024, my lord. Yesterday, my lord, we have
CSN Patnaik Learned AGA submits that he has received parawise comments on 10th of this month and requests for some time to counter. Please this matter October. 3rd October. On 23rd October, counter will be filed in the meantime. Interim order to continue. Item note 35. None appears for the petitioner on repeated calls. It is seen that by order dated 21/8/2017, notice was directed to be issued with specific direction to file requisites by 24/8/2017. Notice was also issued in the connected miss case. More than 7 years have passed, but no steps have been taken to file the requisites. The writ application, the transfer application is therefore dismissed for non-compliance of order of this court. Yes. Item 36. At the appropriate time. Sorry, list sorrow rakha hua. Item 36. Pass over kar deta. Yes. 37. Item 37.
37. Application for transfer of.
Mr. Satpathy, you have taken a liking for that chair. You have taken a liking for that chair.
I think, my lord, the password matter will be taken up.
Nabil, you somehow like that chair.
Sorry.
Kali maro. Hey, Kali Sid Maro Dita, arguing counsel chair. We put a state counsel. Huh? Support a court of Maratha. Oh, say Chetani, I put a court. Yes.
Then a mediation report is there.
The report of the mediator indicates that the next date of mediation is fixed to 20th of this month. Hence, list this matter on 7th October.
Item 38. 38, let's see, mediation successful.
Yes.
That may be indicated in the order.
The report of the mediator indicates that the mediation has become successful. In such view of the matter, there appears to be no
Officer concern there. That will be part of the order.
No, I will direct you to appear before the court below and to get the matter resolved. Na? It is the Havani. I will record it. I will record it. No, in such view the matter. The terms of the settlement has been indicated in the report of the mediator. Stop. In such view of the matter, the question of directing transfer of the case doesn't arise anymore. Both parties are directed to approach the court below with report of the mediator and to pray for disposal of the case in terms of the settlement arrived at before the mediator. Stop. If such motion is made, the court below shall pass necessary orders as soon as possible. The transfer application is disposed of accordingly.
Item 39.
Petitioner is the wife minor, paid before lordship to transfer this case which has been filed by the husband of the petitioner.
What about the service? State was directed to serve. Transfer TRPC number 105 of 2024.
Last another copy has been given.
39.
IIC Doswala PS.
Well, Tapaswini Das versus Sanjay Kumar.
Yes, yes, yes.
Mr. Pulin Martha, AS Paul. He has already appeared.
I am the husband, my lord. My lord,
who is Pulin Martha?
Opposite party.
No. Opposite party is Sanjay Kumar Das.
No, man. Pulin Martha and AS Paul. They are the conducting counsels.
Okay. Counsel.
Yes, ma'am.
No, he is there.
Yes, ma'am.
So you are appearing for the husband?
Yes, ma'am.
Sri S. Paul has entered appearance for the husband. Have you filed Vakalatnama?
Yes, ma'am. Their name is reflected.
Okay. You wanted to be transferred from which place? From Bhubaneswar to Khordha. Kyun? Kahingi?
What a criminal proceeding filed by the petitioner, that is 65 of 24 for maintenance. It is pending before the
Go to mediation.
yes.
Mediation, huh? Date kar do. High Court Mediation Center. Yes.
Item 40.
May I begin to please your lordship?
Item 40.
My lord.
Yes, Mr. Bhuya.
Lordship, I pray for transfer of the CP pending before the Judge Family Court Kendrapura to Patak, your lordship. Reason being, the opposite party is a practicing advocate of Kendrapura and sometimes creating disturbance, for which reason I am unable to prosecute the proceeding in there, your lordship.
Since the husband has already entered appearance, let me ask whether there is any chance of settlement. Why don't you explore the possibility of mediation? Since you are a lawyer, you means your client is also a lawyer.
My lord.
Why not mediation?
My lord.
Why not mediation?
Yes, I am ready for mediation.
Mediation, all right. High Court Mediation Center, date karo?
8 November.
13th November.
My lord.
Item 41.
Yes, Mr. Mahanti, what is this?
Matter regarding.
ସେ ଆରଟାରେ interim order ତ ନଥିଲା ତାକୁ stay କରିଦିଅନ୍ତୁ, stay କରିଦିଅନ୍ତୁ ହଁ ସେ adjournment ଥିଲା. Yes, Mr. Mahanti.
Matter regarding, I am for the wife. Matter regarding transfer of the matter from Bhubaneswar to Cuttack on the ground that I have a small kid and this DB case, CP case and GR case all are pending before the learned court below in Cuttack.
Mediation को ଯିବେ?
Mediation before that also we can take a chance
mediation
also,
can done anytime, and we have got trained mediators, very good mediators. बहुत भलो mediation center हमारा, one of the state of the art, one of the best mediation centers of the country. So
the ambience is much higher than the expectation.
I was also talking about the quality. The quality is also good. Our mediators, our lawyers.
Mediation out there. Due cooperation, it will
Yes,
be
yes.
more.
एक ना तो कोटे settle लेला अपन का आगे कोटे settle लेला देख ले. किच आप settle हो सकती. 80% may not be settled, but let us make an attempt. All right. And matrimonial cases are best decided through mediation.
Yeah, obvious.
Nothing
No
to decide.
law will work out.
What law?
If a understanding is there, everything will fail.
It is all, it's all a question of emotions, ego, and all those
sentiment and understanding is.
All right, ताले कर दियो तो mediation करो केबे को 13th November interim order की चर्चा की
November ता पूर्व
नहीं mediation in the meantime matter will be listed in 13th. In the meantime I have to give sufficient time for mediation. Mediators are also, they will issue notice, they will call you and they will fix 1 or 2 dates. If the before the ensuing date, if the mediation is not over, he will submit an interim report.
Exactly.
So, all right. Is there any interim order? Interim order to
that
stay. All right, continue. 42.
Item 42.
Immediate जाओ हम चेष्टा करियो जते
हेगला बोल
तले they have applied for stay of the matters pending at Bhubaneswar, CRP and CP. Another matter CP they have filed here at Cuttack. It may be also stayed.
So this
we
is
will proceed when that matter is in session.
Well, at both cases stay कर दोगे ना? Stay कर दोगे, ये case कर दो, case report.
नहले पुणे अजथारे को गैंग क्लास करियो.
Yes, 42.
Item 42.
May I begin? Believe the case, I am for the wife petition, wife has filed the petition because there is some for transfer. So CP case from Jagatsinghpur to Malkanagiri, and the petitioner was residing for Malkanagiri, his father was service there.
You are for the husband?
Today I'm happy.
That filed Jagatsinghpur in section 9 of.
Jagatsinghpur to Malkangiri, this will be any chance of settlement, mediation?
I will take instruction.
What instruction? All right, release this matter next week. The party, learned counsel for the parties are requested to inform the court whether there is any possibility of the dispute being resolved through the process of mediation. Yes.
Item 43.
Interim order to continue. 43. Addressee cannot be located.
Lordship, there is a case pending in Jajpur for the CP case number 90 of 22, which is pending before the Family Court Bhubaneswar to be transferred to Jajpur.
Let an extra copy of the transfer application be served upon learned state counsel, who shall cause the notice to be served, cause it to be served upon the opposite party to the IAC of the concerned police station, indicating that the matter shall be taken up for hearing on
7th October, sir.
on 7th October. Interim order to continue.
Item 44.
Lordship, item 44 and 45 may kindly be passed.
Pass over. On whose behalf are you making?
Your Lordship, on behalf of Binny Mishra, she'll be conducted.
All right, pass over.
Item 46.
Pass over.
Item number 47,
Pass over.
item number 48,
Pass over.
item number 49,
47, I think.
47 ki naati. Let us wait. Let us wait.
My lord, item number 48.
Document
Appearing
ଆପଣ କହୁନାହାନ୍ତି ଆଉ. Yes, 48.
I'm appearing from the petitioner
Yes.
and pending verification of the document.
Verification of the order considering it is directly the petition will be released on bail till September. Oh, today. Till today.
he is suffering, my lord, and no one is there.
My lord, praying for 4 months. Into
4 months.
4 months.
Regular bail तो दे देबे और 4 month काहे कि देबे आगे.
My lord, surgical procedure is also there.
ऐसे जहाँ हबो कौन. Land State Council has obtained written instructions from the concerned IAC to the effect the mother of the petitioner is in fact suffering since long and is under treatment. Stop. Further, there is no one to take care of her except the petitioner. Stop. That apart, the medical documents enclosed to the IA were found to be true and genuine. Stop. Considering the above, the interim bail granted to the petitioner by the order dated 3/9/2024 is extended by a further period of 2 months. List this matter on Dimas Pore. 20th November. Yes.
Item number 50, item number 49.
Yes, of 302, my lord. So for the yes or part is concerned, it is attributed to one, my lord, Tolia Deuri.
Case Deuri ଅଛି?
Yes, madam.
Yes.
And
Panwa
according
Deuri.
to those who are stands on the same footing, the lordship was pleased to grant bail.
This petitioner stands on same footing, but omnibus allegation is there, my lord, no specific. But he was soon after the incident, he was absconded he was arrested in NBW was issued on 14/4/24.
So he stands on the same footing?
Yes, yes. A lordship have observed that Pratap Barik, Govinda Barik, Manjulata Barik, they have the injured eyewitness. And they stated that
main allegation of assault is directed against Dolia Deuri, Kalia Deuri, Piltua Deuri, Bhishma Deuri, Ananta Deuri.
Ananta Deuri.
What is your name?
This petition by Panwa and Santas.
And the person allowed, my lord, paragraph 11.
So Ananta Deuri are rejected.
Mine.
Yes.
Same dekhi karo. Correct the same order?
Yes, my lord, same order.
Last
Absolutely
same. Costed director.
No, ये आपण you are Panwa Deuri.
Panwa alias Santos.
ତାଙ୍କ ନାଁଟା ସେ କହିନାହାନ୍ତି ସେ ଡୋଲିଆ କାଳିଆ ପିଣ୍ଟୁଆ ଭୀଷ୍ମ and ଅନନ୍ତକୁ କହିଛି ଅନନ୍ତ ରାସ୍ତାରେ ଅନନ୍ତ ରିଜେକ୍ଟ ହେଇଛି
That was rejected.
ଅନ୍ୟମାନଙ୍କର ଆଲୋ ହେଇଥିଲା ସେ ବାବୁଲି ଦେହୁରୀ alias ବେହେରା ତାପରେ କୁଳମଣି ଦେହୁରୀ ହେଇଥିଲା ଏଇଟା କରିବ
that line I am reading one of the statement the Pratap Barik. My lord, deceased is one Kartika Barik and ଏତିକି କଥାରେ ପାଟିତୁଣ୍ଡ ହେବାରୁ ହଠାତ୍ ଦୋଳିଆ ଦେଉରୀ he is the principal accused ମାନେ ହାତରେ ଏକ ତକ୍ତ ପଥର ଧରି ମୋ ବଡ ବାପା କାର୍ତ୍ତିକ ଦେଉରୀକୁ ମୁଣ୍ଡରେ ଲକ୍ଷ୍ୟ କରି ଛେଚି ଦେବାରୁ ସେ ତଳେ ପଡିଗଲା then କାଳିଆ ଦେଉରୀ ପିଣ୍ଟୁଆ ଦେଉରୀ ଅଭି ଦେଉରୀ ଭୀଷ୍ମ ଦେଉରୀ ମାନେ ସେ ପଡିଗଲା ପରେ ହଠାତ୍ ଧରିଥିବା ବାଉଁଶ ଠେଙ୍ଗାରେ
ୟାଙ୍କ ଏଗେନ୍ଷ୍ଟ କିଛି ନାହିଁ ଆଉ
ନା
same order.
Yes.
Costed director खाली.
The petitioner is in custody since
14/4/24.
14/4/24. Yes.
14/4/24.
Your bail was refused.
Bhagirathi Gowda.
Yes, sir. Who accused your lordship granted bail? Custody my lord, more than a year. Bail was refused 5 months back, my lord.
What is your name?
My name is
Bhagirathi Gowda alias Bhagya
Bhagya
Gowda. Elaborately, your lordship has.
Bhagirathi assaulted him on his head by means of
Nice
stone.
reading this. First time as well. No change of circumstance, your lordship has rejected. Your lordship see the earlier order in two bail appeal orders 13975. अच्छा मास भी change कौन है sir?
There is a quarrel in the
It
village.
is direct allegation against
Yes,
this
ma'am.
Bhagirathi. Assaulted him on his head by means of a stone.
Elaborately, your lordship has dealt, my lord.
Some days your lordship consider.
আইটা ফাইল করো না আইটা ফাইল করো আইটা ফাইল করেছ না কোন একটা কনসিডার করা হবে এথরা হবনি
ঠিক আছে that's how I'll go.
As requested by counsel for the petitioner, list this matter kebe next week.
Item 51.
In the meantime, sitting.
In the meantime, up to date case diary up to date না খালি case diary be up to date.
Next week.
তাহলে next week হবনি তা পরে বিক্রি করে next week আনি পারিও না পড়ে পারিও
ମୁଁ ତାହେଲେ ଆଇଟା ଫାଇଲ କରିଦଉଛି ଆଉ ଠିକ ଅଛି
ଆଚ୍ଛା ଠିକ ଅଛି ଛୁଟି ପାଇଁ ଆହୁରି ମାସ ରହିଲେ ଏତେ ବ୍ୟସ୍ତ କଣ
ଠିକ ଅଛି ଆସ ତାହେଲେ
ତା ପର ୱିକରେ କରିଦେ 25th.
Item 51.
List this matter on next week ତା ପର ୱିକରେ 25th September as per for interim bill ଅଛି କି ଏ ଯୋଉ interim protection order interim order to control.
Item 52.
52 million here. Allegation is that huge quantity of ganja was recovered from community in front of a community hall of a village. Thereafter, no, all the co-accused persons were accused. Bail. Your lordship granted bail. I have annexed 2. All the villagers were implicated, and your lordship annexed. Kindly see annexed 2. Your lordship has granted bail. Almost.
The local inquiry, they have ascertained those name. And some altercation between the police person and some police person injured and not seized from the.
Correct. Password go to I will take it up after recess.
Hello, my case same order.
If you want an adjournment, I can. Huh? It's the same order. Mr. You are in item 19. Yes.
They have not served the copy of the counter.
So you want an adjournment?
They have not served the copy of the counter.
Serving,
I'm serving.
You are the petitioner?
I am the opposite party. I am the petitioner.
Achha. Let a copy of the counter filed by opposite party number 5 be served upon learned counsel for the petitioner. Further, list this matter on 7th October. Yes.
Weekly list item 7 काली जोटा थिला से सब्सक्रिप्शन कॉपीटा मते देइछन कि ठीक देइछन भूल देइछन मु टिक इन्फॉर्मेशन नेबी इंस्ट्रक्शन नेबी
हाँ मु आसला पर तो अर्जन करबा कोन इफ यू आर नॉट देयर इट विल बी ऑटोमेटिकली पास्ड ओवर
मु रही परिम टे डिल
हां जा किछ
मेंशन कर दे
आइटम 7 टा पास ओवर खाली कर दो पास ओवर फॉर द इट विल कंटिन्यू टिल फ्राइडे और कोन नो यू वांट एन एडजर्नमेंट
हाँ नेक्स्ट वीक रखो इंस्ट्रक्शन देबी सब्सक्रिप्शन पेटिशन ता जे 8 वर्ष डिले रे फाइल कर दिन
अच्छा हो आइटम 7 वीकली लिस्ट तो एडजर्न कर दो What date?
We commencing 25th November.
Is this matter in the week commencing
5th November.
25th November? Why are you looking so sad?
My lord, should I make a mention?
Yes, please.
My lord, that advocate commissioner report which your lordship was
Yes,
kind of.
yes.
My lord, it is coming tomorrow. If I deposit in the registry, it may not come in the list. My lord, should I?
You have completed the inquiry?
Yes.
Very fast.
Your lordship fixed the time that you should submit before 9th, on or before 9th.
I thought you will take time. Anyway, tomorrow in the court itself, can you?
All right.
No, what do you want? You wanted it to file it today?
I'll deposit before the court master if your lordship permits, or tomorrow.
Tomorrow it will be better.
Yes. The registry has not cleared by bill as yet.
No, that I will pass a judicial order. What are you saying?
That
Don't worry about that. Don't worry about that.
But I have done on 7th itself, I have done.
No, it actually, I have said that both parties will bear the cost jointly. So they may not have deposited.
No. They have deposited. The registry has not cleared.
Because of some formalities,
Yes.
you know.
No, because the list, it is coming before your lordships tomorrow. So they could not bring the file and.
Okay. I'll pass a judicial order in that.
I'll deposit tomorrow.
Yes. Is it a video? Is it a video?
Well, that is the reason switching due to.
Yes.
So item number 36.
Weekly supplementary list. Item number 36. 2000. None appears for the petitioner. None appears on repeated calls. This is a case of the year 2017. This court finds no reason to keep it pending any longer. Stop the transfer application is therefore dismissed for non-prosecution.
So item number 44.
Yes,
Wait, please, Your Lordship.
appropriate orders.
Been granted bail by this honorable court by court order dated 9/4/2024, Your Lordship.
9/4/2024. Yes.
Condition that the petitioner has to submit short-term fixed deposit of rupees 10 lakhs, Your Lordship.
Cash security of rupees 10 lakhs in the firm. Yes.
However, he is not able to give the same, Your Lordship.
So, an economic offense. So,
Economic offense, and your lordship has reduced from 26,60,470 to 10 lakhs.
yes.
Despite trying his best, Your Lordship, he does not have any parental resources or any resource to meet this requirement, Your Lordship. So, Your Lordship.
He has to deposit some amount. You take instruction. What can be a amount what can be the amount which he can deposit? Yes. Tell me.
I have instructions that he can deposit up to 1 lakh, Your Lordship. I know, Your Lordship, that is not a reasonable submission on my part.
You see, when I want to grant bail,
Yes.
I normally grant bail without any conditions. But whenever I've imposed some conditions, looking at the magnitude of the offense, here the amount is 26 lakh and admittedly there's a strong prima facie case against you. In spite of that, I've granted you bail. How
Your Lordship, I may be permitted to take that instruction.
Yes. Is this matter next week as learned counsel for the petitioner wants to take instructions from her client? Yes. Arata?
Item
45?
45, Your Lordship. Your Lordship, in item 45, trial has proceeded and 12 witnesses have been examined, Your Lordship. In the meantime, some of the witnesses have also been recalled. So we have to submit before Your Lordship the certified copies of those recalled witnesses.
Depositions.
Yes, Your Lordship.
When do you want? When can you supply
Next
these?
week, Your Lordship, any day.
Is this matter next week as prayed for? Learned counsel for the petitioner.
A week after that, I will not.
Okay. Is this matter on?
25th September.
25th September. Learned counsel for the petitioner undertakes to file the copies of the depositions of the witnesses examined on recall by the trial court.
So right now 46.
46. None appears. Is this matter 1 week after?
So right now 47.
Yes, 47, you were saying something, Mr. Mishra?
No, madam, no efforts.
All right. None appears. 1 week after. Happening. Sorry.
47 that interim bail was granted for 1 month is from West Bengal, so.
He did not
I
surrender.
think-
Don't blame the court for rejecting all the interim applications there. This is what happens.
Yes.
The court below, it is 47 lakh. The court below is directed to inform whether the petitioner has surrendered to custody after expiry of the interim bail. Is this matter? What date kar de?
25th September.
On 25th September. Yes. This order be communicated to the court below forthwith. Order 41 Aramo, no?
Item 19 was passed over supplementary.
19 he.
Arjun.
7th October. Total list item number 26.
Lord, in this case, the respondent number 1 is dead. And it was abated, so I have already taken steps for substitution of the legal heirs of deceased respondent. I have also served copies on.
When did he die?
And it was reported that it was informed by intimated by the learned counsel appearing from the respondents on 6th of April 2024 that he is dead. And
Matter has not been admitted.
it was
2003
not-
matter.
It was not admitted. And but the record was called for at the relevant time, and there was LCR also has come.
No, Justice Behra's order is that respondent number 1 has expired since the year 2020.
Yes, that was intimated by the court. I was not aware of that, and therefore, after the intimation, I
I can only grant you 1 week time to file.
I
To
have
take
already
steps.
filed. Ma'am.
You filed
Yes,
the.
madam. Yesterday I have filed and I have served copy.
Date of knowledge collection.
From the date of intimation, previously I didn't have the knowledge. Apuna? Learned counsel appearing for both the parties are present. Learned counsel for the respondent submitted that the respondent number 1 is expired since year 2020.
Have you taken steps for substitution?
Yes, my lord, I have already taken.
File question.
File करचली.
My lord.
तल काली स्वाजी मगे देसे
IN number 1057 58 and 59.
57 58 59. 1057 1058 1059. मगे दे काली. आजी पास ओवर था कल की नहीं.
Notice legal error दरकार नहीं.
आगे?
L1 को notice पता है.
नहीं से फाइल का सु से record आये उड़ा नहीं. आजी नहीं हमारा record नहीं.
हाँ, असली order पे करता.
से असले काली करी पे order था.
ठीक है.
तेरा पास ओवर था वो for the day.
हाँ.
Item 27.
नहीं थिले मो इखने notice कर दी था किंतु नहीं तो.
उन्हें record टा अच्छी.
आसु. Item 27. Writ of interim status quo notice issued on sole appellant returned unserved with a report of postal authority is not living in his place of residence. Anyway.
I will pardon your lordship. The conducting counsel for respondent number 1, 2, 3, Mr. G.N. Raut is on his legs in another court.
Yes.
It has not been admitted. Yes.
This is a question of admission. Status quo has already been passed.
Yes, your lordship was kind enough to issue notice on 13/1/2016.
Yes.
Well, it's a reversing decree. The defendant number, the sole defendant is the appellant before your lordship. The plaintiff suit was for declaration of right to enter interest over a scheduled land, recovery of possession and compensation, and restoration of possession by. That was dismissed by the learned court below, holding that the plaintiff is not the sole owner of the property. it was a government land which was settled in favor of, in the name of the plaintiff, and therefore all the brothers have equal right over the same, and state was not made a party. The learned trial court dismissed the suit on 3 grounds. First, holding that it cannot be treated as exclusive property of the plaintiff. Second, state was not made a party. And once it is the property of the state, the plaintiff cannot claim compensation from the defendant. The suit having been dismissed, they preferred appeal. The appeal.
What is the role of the defendant in this case? How is the defendant in?
Brothers. They are brothers.
Okay. Then?
The appellate court reversed the entire finding and decreed the plaintiff's suit. Against that, I have come up in appeal before you.
What was the finding?
My lord, finding was state is not required to be made a party. Once it is having been settled by the state in favor of the plaintiff becomes absolute owner of the property. And because I am in possession of the property, I have to pay compensation to the plaintiff.
What is wrong in this finding?
Yes. My lord, first of all, the property in question, the original owner was the state. It was settled in the favor of the plaintiff, number one, because he was the eldest, he was there. The defendant was serving outside. So the father being in possession of the property, it will be treated as a property belonging to the father, not to the eldest son, which the plaintiff claimed.
Law of primogeniture.
Yes. He applied that principle and said that no, elder brother will get everything. The state was not made a party. That was the specific point on which the suit was dismissed.
Where are your substantial questions?
My lord, your lordship may kindly turn to page 8. My lord, B and A, if it is done, and one more point, my lord, which I missed at that time. By experience, we get knowledge that provision of Order 41, Rule 31, your lordship may kindly see. It says the appellate court has to frame the points of determination. There are 2 judgments of the Honorable Appellate Court.
Both sides' judgments are there.
But
Both
latest view of the Honorable Appellate Court is that once the point of determination is not framed, the appeal is incompetent to be heard. Of course, that is my secondary argument when I seek for a remand. But if your lordship holds my ground number A and B.
4131, you see, it says, the line of judgments that I have seen is that if the points without being framed have been substantially considered and
yes,
discussed,
but
then
question is, my lord, when an appeal is being heard, this like a suit, the issues are casted. The appellate court cannot just follow that issues.
No.
It has to recast because it is the last court of fact and law.
I'll tell you, it varies from officer to officer. Normally, points for determination are framed.
Yes.
After noting the rival contentions,
yes.
I have not disposed of a single first appeal without framing points of determination. But then, supposing points are not framed, but whatever the points are involved have been taken care of by the court, that the second appellate court
can take note. Lordships to decide. But as an officer of the court, I should point out that these are the trump card before me that I can place before your lordship. If it is
then A
and B.
A and B will do, yes. That's the AP Bose, Learned Counsel for the appellant. Peruse the impugned judgments. Considering the submissions and the grounds raised, the appeal is admitted on the following substantial questions of law. Page 8 or A or B. Since the respondents have already entered appearance, no notice need be issued to them. Let copies, adequate number of copies of the appeal memo have already been has already been served on them. Call for the LCR. Place this matter.
18th November.
December. 9th December. Okay.
Interim order to continue.
There's an interim order.
Yes.
Interim order to continue.
Item 28.
May I please, my lord? My lord, the plaintiff is the appellant. My lord, I may be pardoned, I am online.
No,
My
you
lord,
should appear physically, Mr. Mishra.
I am extremely sorry. Some people, but there is a small point involved. If your lordship kindly accept my submission, then I'll have a case. I may just with your lordship's kind permission present it, my lord. I was
Yes.
there in court, my lord. I had to rush back and my lord, I was there, my lord, in court. May I please?
Yes.
The plaintiff is the appellant against reversing judgment. Suit was filed. Man, he possibly appeared in limitation matter. If your lordship accepts my appeal, then only question of he again accepting notice will arise. My lord,
No, notice was issued on limitation.
and that
The delay has been condoned.
condoned subject to cost. Cost has been paid.
Okay. Okay.
My lord, just to start with the facts again, the present appellant was the plaintiff, and he is before your lordship against reversing judgment. Suit was filed for declaration of right title interest for confirmation of possession. Admittedly, both the parties have purchased property one after other from the same person who had got a pata from the intermediary, and thereafter the son succeeded from whom the parties purchased. My sale deed is earlier in point of time in respect of 50 decimals. The sale deed of the defendant is subsequent in point of time in respect of 50 decimals. However, in the settlement record, it was recorded as 54 decimals. Since there was dispute, suit was filed. Now, the learned trial court, your lordship will kindly find, my lord, at page 14 of the internal page 14 of the trial court judgment, specifically observes that the defendant is no manner having that 4 decimals extra right title interest and possession, and declares my right title interest and confirms the possession. Now, the decree is at page, my lord, the operating portion of the order is at page 17, your lordship, and 18. My lord got
Yes.
it, my lord.
Yes.
Then now the appeal was carried. Now the learned appellate court reverses the judgment saying that since I am not in possession and possession is with the defendant, in the absence of a prayer for recovery possession, the entire thing is misconceived and it has been set aside. Now this honorable court has been pleased to hold that if during the course of the case, the court finds that in fact there is a need of recovery possession in the interest of justice, it can be passed. So if the appellate court thought it proper that there should have been a recovery possession, instead of dismissing my appeal, there should have been decree for recovery possession in modification of thereof, not dismissing my claim altogether, saying that I have no right title interest and everything. Therefore, my lord, subject to your lordship's kind acceptance, I have formulated the substantial question of law at page 10. Your lordship may kindly peruse P Roman 1 and Roman 2. It is, of course, my lord, alternative in nature. In the sense, if the first one is accepted, then the second one will not come into picture. This is the question of law only I have formulated for your lordship's kind consideration. And my lord, subject to your lordship's permission, 92 Orissa, 2006 Orissa, and 7392 CLT also are on the same point.
All right. Lord Sri Samir Kumar Mishra, learned senior counsel with so and so for the appellant.
Miss Pragya Mahan.
Yes.
Miss Pragya Mahan.
With Miss Pragya Mahanti.
She's there, man.
Learned counsel for the appellant. Peruse the impugned judgments, considering the submissions and the materials and the grounds raised. The second appeal is admitted on the following substantial question of law. It is page 9 ro. Whether the learned appellate court to jotha ramichi jota 1 ro seta kablo court korbo. है ना?
मैं second टा रहियो ये वर्षी.
Second टा थाउ दरकार नहीं. सेटा तो depend करछि whether the finding is perverse. तो सेटा second टा भी कर दो. Two टा भी कर दो. Issue notice तो दरकार नहीं. You have already.
I am for the only respondent 1B to D. Others are there. I am for 1B, C. And
Others had not appeared pursuant to that notice.
Oh, I am sorry, my lord. Substitution notice. I stand corrected. I am extremely sorry, my lord.
Yes. So notice has to go to all. Well, excepting those who have already appeared. You have appeared for respondent number 1.
B to D.
1B to D. Since respondent numbers 1B to D have already entered appearance, no notice need be issued to them. A copy of the appeal memo will be served upon learned counsel appearing for these respondents. Issue notice to the other respondents by registered post with AD. How other key questions? 1A.
ସମସ୍ତେ ତାଙ୍କରି
Yeah, see, appear corona te kon issue notice to the other respondents by registered post returnable within 4 weeks, requisites within 3 days. Call for the LCR, list this matter.
9th December.
In the week commencing 9th December.
Obliged.
May I plead the lawsuit? The respondents are the plaintiff, appellants are the defendants before the trial court matter. Plaintiff filed a suit for partition. That was expected decree matter.
Partition.
Matter.
DT's property?
Matter, that is a family duty matter.
Much.
That's filed a suit for partition matter. That was expected decree matter. And after knowing the expected decree, the appellants filed an appeal before the lower appellate court matter with a limitation application. The delay is of the year, the delay is 586 days matter. By taking a plea that the advocate clerk was dead, and in the meantime, the advocate could not properly step. So that was the suit was executed. But the lower appellate court dismissed the appeal on the ground of limitation matter. So when this appeal was first appeal was dismissed.
Let us issue notice on the question of admission. Let us issue notice. Issue notice on the question of admission by registered post. Requisites be filed within 3 days. Short returnable date be fixed. Let this matter on. What is short date? In the week commencing 21st October.
Can I pray for stay of final decree?
I record final decree proceeding shall continue, but the decree shall not be sealed and signed. It is the next date.
Okay.
I do not 30.
My future. Your Lord, I'm the defendant before the trial court and appellate before the lower appellate court. It was a Lord suit for eviction. Suit for eviction and for announcement of rent. We have vacated the premises. In the meanwhile, in 21, we have vacated the premises. So, my Lord, the only question now arises that whether the direction made to pay the rent at the rate, whether it is sustainable or long run. The court directed to pay 40 rupees per square feet. We are paying 8 rupees 90 paisa per square feet. Court directed 40 rupees per square feet. There was no basis on the document. There is no basis. You will also may kindly see the judgment of the trial court. A very short one, Lord. Page 15, internal page 15, running page 47.
Yes.
With regard to the issue of the suit claim made by the plaintiff to a tune of 89,880 from the month of December 17 to till delivery of possession, this court once again perused the plaint and testimonies of PW1 and 2 and further examination of chief of PW1 and 2, and it is found that not a scrap of document has been filed by the plaintiff to show that the suit schedule house properties have been let by the plaintiff to the defendant at the rate of rupees 40 per square feet. But at the same time, as per notice by Exhibit 3, the plaintiff have informed the defendant about the present market rate of the suit schedule house will be at rupees 40 per square feet. But no reply has been received by the plaintiff from the defendant. At the same time, the defendant has alleged that there was no term and condition for payment of rent at the rate of rupees 40 per square feet after the completion of term of 1/12/15. But the plaintiff have accepted the tenancy of the defendant after receiving the monthly rent. At the same time, the plaintiff filed Xerox copy of the lease deed for installation of ATM
of SBI through testimony of PW1 to show that the said land has been let out to the State Bank of India for installation of an ATM for 40 rupees per square feet. No rebuttal evidence has been adduced by the defendant in that respect, since it has been admitted by the defendant that he has flouted the term and condition of lease deed by Exhibit 1, and he has admitted that he has been paying monthly rental to the defendant regularly, even after expiry of the lease period, as he was admitted that his tenancy has been accepted by the plaintiff. Such admission of the defendant and on reply of the notice dated 2/11/17 by Exhibit 3 compels the court to take a presumption and give its view that the plaintiff are entitled to such rental. No document was filed. The Xerox copy was given. And even it was not marked as X. So when he filed an application before the trial court to call for that document, the court rejected it on the ground that this has not been marked as X. Then, my lord, I'll come to the question. Here, your lordship, kindly see this page 5, this is of Exhibit 1. Here, my lord, the tenancy had not expired. Kindly see, my lord, page 5. Page 5, your lordship, kindly see, it was initially for 5 years. Just Lord, let see first. First internal page 3, my lord, in the 1, 2, 3, 4 at line 5, belonging to or appertaining to the same for a term of 5 years, 5 years at a monthly rent of 19,661, commencing from 1/12/2010. Thereafter, your lordship may kindly see page 5. This is the admitted document. This commenced on 10 and it was to expire on 31/11/2015. Then internal page 5 para 2, that in the event the lessee not being desirous of exercising the option to them herein before reserved to renew the lease deed for further period of 5 years, they shall not less than 3 months before expiry of the term of the lease deed give the lessor intimation in writing of their intention not to renew the lease. Failing notice, it will be held that the option is being exercised. That means it is continuing, my lord. This part has not been taken into consideration. And the learned lower appellate court take into consideration some of the decisions which are totally different, my lord.
Yes. Now, what was the finding of the first appellate court?
Your lord's my kindly first appellate court.
Now, how has he dealt with that 8.37 rupees that's per square feet? How has it been justified to be rupees 40?
That's what I'm saying. The trial court said because they have given a notice.
That is, trial court has proceeded on presumptions.
Lower appellate court has
that is, he has proceeded on presumptions. How was the first appellate court?
Yes, my lord. What lower appellate court said. Lord, the judgment of the lower appellate court, your lordship may kindly see page 16, para 14. They took into decision the learned appellate court, lower appellate court took into consideration the decisions. Last 2 decisions are regarding this. That is 2010 CLT 493 and 34 Allahabad 115. And the finding is para 14. Here in this suit at hand, when as per the quit notice dated 1/11/17 by Exhibit 3, the plaintiff landlord had requested the defendant bank to vacate the suit house building within 30 days from the date of receipt of that notice, or else the defendant bank is liable for payment of enhanced rent at the rate of rupees 40 per square feet. And when the defendant bank received that notice by Exhibit 3 dated 3/11/17, and when the defendant bank remained in possession of the said building after 3/11/17, when the learned court below, though impugned through the impugned judgment and decree, directed the defendant bank to pay an enhanced monthly rent at the rate of 40 per square feet of the terminated premises since 1/12/17, that is at the rate of rupees 89,880, then at this juncture, in view of the ratio of the aforesaid decision referred to supra, it cannot be at all held that that the imposition of enhanced rent at the rate 40 per square feet of the dwelling in respect of the suit building for the occupation of dwelling is illegal or erroneous in the matter. But my lord, so far as that decision is concerned, in 34 Allahabad, what had happened, there a notice was given for terminating the tenancy. There the option was given that either you leave the house or pay this and this amount from that. They left the house. But they did not pay.
No. What I find is there was a notice to quit.
There was a notice to quit. In my case, there was no such demand. Your lordship may kindly see that document.
No, here, but the first appellate court says that there was a notice to quit on 1/11/2017, which was marked as Exhibit 3. There was a reference.
Where it is given Exhibit 3 that.
No, there was a reference made therein in that notice to the enhanced rate of rent at the rate of rupees 40 per square feet. I would like to know whether there was any such agreement.
No, my lord. In fact, the agreement has not even expired. Your lordship may kindly see that notice.
So the same agreement continues, which says that the rent is 8.737. Same agreement.
Agreement is there.
Okay.
But in that notice, your lordship may kindly see Exhibit 3. First, your lordship may kindly see Exhibit 2. This is also a notice, and Exhibit 3 is the advocate notice.
Good.
Exhibit 2, my lord, this is given by Shashi Sahu. While inviting your kind attention to the above, we inform you that no steps being initiated at your level to vacate our premises. As a result, we are unable to start business of our own at our own premises to earn our livelihood. That finally, as you have not vacated the premises, we have no other alternative but forced to meet the family expenditures by beg, borrow, or steal. That in such circumstances, we are pushed to huge loss, both by your pecuniary loss and mental tension to ourselves and our family members as a whole. Hence, we would approach your good self to take suitable action in the matter to bring home discipline and social responsibility the bank is supposed to perform in case of poor landlord like us. Finally, we will have no option but to take the matter to Reserve Bank of India and judiciary as well. Below your lordship may see then the third notice. The second notice, the advocate's notice, your lord. That is Exhibit 3. Exhibit 3, first para 9, your lordship may kindly see. Page 1. Grounds, my lord, sort of A, B, C, D, my lord. Formulated, my lord, under A, B. Well, A, B, C, D. A. Yes. I have prayed for stay of execution. Yes. Yeah.
9th December. 9th December.
You should attachment, my lord. EP 3/21. My lord, may stay further proceeding of the execution. Yes. Look. That was not perhaps for payment of court fees. Yes, I have paid. Stay, my lord. Yeah. For the proceeding and execution. Yes. For the stay for the proceeding and execution. Yes. 3/21. Civil Judge, Senior Division, Barampur.
So 9th December.
Item 15. Urgent copy.
Item 31.
And then the appellant against the company servant.
Yes.
Suit for partition. Is a dispute between the brother and sister only.
Yes.
The suit property belonged to the mother only. The mother died in 1975. Father married for the second time. He had 3 sons and 1 daughter from the second wife. Therefore, my lord, she has claimed half share of her mother property. In the written statement, I have categorically mentioned that the property of the mother and the ancestral property were earlier divided by a unregistered deed of partition. And this property fell to the share of the defendant.
Yeah, again, say who is the defendant?
Brother, my lord.
Brother of the plaintiff.
Plaintiff.
So both are children of the children of the recorded tenant, let us say.
Again.
So, children born out of the second marriage or of the first marriage?
First marriage.
Of her first marriage. Now there are other parties, other children born out of the second marriage also.
They have not included as parties.
They have not been implicated as parties.
Neither the father also was not included as parties.
No, it's a question of absolute property of
Yes.
that question is also raised automatically.
Because the mother property, it is the absolute.
In one of my judgments, I have held that even the children born out of the second marriage will also, in my view, I have taken. They will also.
Entitled to get it.
Yes. And another matter I have heard and I have reserved judgment where is Mr. Popular Author and.
It is paid for non-gender or party, my lord. I have also taken that as ground.
Whatever, no, not on this case. I'm not passing any order here.
Stated in one of the ground, my lord, it is paid by non-gender of necessary party.
Because once it becomes her absolute property and section 24 has been obliterated from the statute. So section 14, my view is that it cannot never be watered down because the statute confers absolute authority on the female. It is her property, she can do whatever she wants. And if she dies intestate, all her successors will automatically get into the, you cannot divide that, second marriage, first marriage. This is my view, I may be wrong.
That's ground I have taken that is bad for non-gender of party. He has not made party. And the specific plea which was taken that it was come to the common.
The non-gender of those persons.
Those persons and father?
The father was alive?
Yes.
Okay.
Father is alive.
Okay. So what happened? The suit was decreed.
Decreed.
Yes.
Granting half share to her.
Okay.
Appeal dismissed.
Suit appears to have been dismissed very in picture.
Written statement, that has never been discussed.
Okay, then appeal?
Appeal ta pura straight confirm. Kichi mane se bhi kichi lekhina.
Okay. We'll do it 1 and 2 and we'll add another relating to non-gender of parties. All right. Third Ms. Dipali Mahapatra, learned counsel appearing for the appellant. Appellants?
Appellant.
Appellant. Peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Page 6 row I, page 7 row IA. Hela. Tapre I 3 ta muda kuchi dekho. Whether both the courts below were correct in decreeing the suit without considering the effect of non-joinder of the children of the recorded tenant out of her second marriage as parties to the suit. That's all. Issue notice to the respondent by registered post with AD returnable within 4 weeks. Requisites be filed within 3 working days. LCR be called for. List this matter on 9th December. 9th December. IA lakho. Final decree proceeding shall continue, but the decree shall not be sealed or signed till the next date.
Item 32.
Item 32, your lordship, is pending before the mediation center. And the next date is fixed on 20th September. So the matter may be
It is submitted that the dispute between the parties is pending before the the matter is pending before the mediator, and that the next date of mediation is fixed to 28th of this month.
20th of September.
20th of this month. Hence, let this matter
21st October, sir.
21st October.
Item 33.
Please, your lordship. No. RSA number 438 and 437. As per the noting, your lordship, I have to take substitution steps for substitution of respondent number 11 and 15.
What about the other matter? First matter?
The two matters, madam, against the same judgment, they were not made party in the appeal, for which matter I have filed an application to grant leave to file the appeal.
No, but you have directly filed an appeal. Where is the application?
ସେଟା ହେଇକିରି allow ହେଇକିରି
Allow ହେଇଯାଇଛି ତ?
ଆଜ୍ଞା
It has been allowed.
ଆଜ୍ଞା ଆଜ୍ଞା
Oh, they being the daughters of the deceased respondent have the right to sue. So I is allowed. You have been made parties.
26 22
So we will take all these appeals together for admission, and then let all these matters be
ନାଇଁ admission ତାଙ୍କର admit ହେଇଯାଇଛି
admit ହେଇଯାଇଛି.
ଆଜ୍ଞା
Admission ରେ ପୁଣି ଆସିଛି କଣ ପାଇଁ?
The noting as
Noting as
after issuance.
ଫେର order ରେ ଆସିବା କଥା ନା ଆଉ। ଯାହା ପାରିଲେ ସେ କରିଦେବ। ଯଦି admit ହେଇଛି, their appeals have been admitted.
ଆଜ୍ଞା ମୋର ବି ସେମିତି formally admit କରିଦିଅନ୍ତୁ
ତ କରିବା।
ସେଥିରେ notice ଫେରିଛି respondent 9, 12, 17, 18 ରୁ I am
Addressee
appealing for
absent.
the 3 to 7.
Addressee absent and AD not bank for 1 and 2. Undelivered from respondent number 11 and 15 with postal report dead. So you have to take steps for respondent number 11 and 15. He, whoever. अच्छा चलो गोटे काम
With
करो।
regards to 9, 12.
तुरंत You have to take fresh notice.
Fresh notice.
ହେଲା? RSA 437 of 2023. Fresh notice by registered post be issued on respondent number 9, 12, 1, 2, 9, 12, 17 and 18. 1, 2, 9, 12, 17 and 18. ହେଲା? Short returnable date be fixed. Requisites be filed within 3 working days. Steps for substitution of deceased respondent numbers 11 and 15 be taken within 2 weeks. Right? Anonymous hearing देखिबा पछरे आगो ई सब जिंस ये जाउ then we will together. आरो मैटर भी सेम ऑर्डर हो। आरो मैटर सेम ऑर्डर हो। बाकी आपन मैटर दिना थाउ।
पार्टी सेम
एडमिट एकातर हबो काय बेस्तो छु। एडमिट हो हियरिंग गुलो एडमिट हे परिबोनी।
गोटे जजमेंट
एडमिट हबो। Because you were kept out of the proceedings. I remember now.
Interim order may be continued.
Interim order to continue. Yes.
Much obliged.
Is this matter on? 9th December, in the meantime, you have to take steps for substitution.
गुरु दिन चली आसो से 11 12 देले से ना
चलो गोटे काम करो आपण गोटे काम
7 दिन भीतर न आसले 11 12 न
7 गोटे वीक भीतर गुड डेट कर दियो 2 वीक्स टाइम दिया छै ना 2 वीक्स टाइम
11 15 भीतर न देले
2 वीक्स टाइम पर करो 30th September
आगे
so that you will be in a position to
आगे नोटिस इशू हो से मानो ना ता लेगा ले
okay
Much obliged.
34
May the appellant is the plaintiff challenging a reversing decree. Suit is for declaration of right title interest and confirmation of possession. The plaintiff and defendants are brothers and sisters. So for defendant number 2, excepting defendant number 2 and 4, other
no
defendant.
plaintiff is Vijay Chandra Mahathi.
Mal.
Defendant number 2 is Rabindra Mahathi. They're brothers. They're brothers.
Mal.
Okay.
Other
defendants are
brothers and sisters.
Okay. What
Out
happened?
of them, only 2 and 4, Ambaresh Mahathi and that Rabindra Mahathi, they contested the suit, others did not.
Title over the suit house.
Suit house.
What is that suit house?
Yes. Case is that, the appellant is a retired teacher. Now,
Yeah, who is the appellant? Plaintiff or defendant?
Plaintiff. against a reversing decree.
Reversing it.
Look, the suit was decreed in favor of the appellant and it was reversed by the first appellant. Lords, case is that, Lords, in 1985, the petitioner, the appellant joined in service. Out of his savings, Lords, in 1987, he purchased the suit house by the registered sale. Lords, the title has flown like this. Lords. One Udayanath Mahapatra was the original vendor. From him, one O Sabitri purchased the suit house, and thereafter the appellant has purchased the same by the registered sale deed executed in the year 1987. Lords, in 2017, for a financial transaction, that suit was, though it was purchased by the appellant, but it has been recorded in the name of late father of the appellant and all the parties. The necessity did not arise in between for correction. 2017, in the financial transaction, the bank asked me to furnish a mutation, pata, after correcting I requested the parties. They did not. Thereafter, I filed the suit. Now, Lords, your Lordship may kindly see the trial court's finding, Lords. Page running page 70. Running page 70, internal page 27 of the trial court.
Yes.
About 6th line from the top. On perusal of the said document, it reflects that it has been executed by the vendors of the plaintiff in favor of the plaintiff on 27/1987 for a valid sale consideration amount being signed by both the parties concerned as well as the witnesses. The said document is registered in the office of Sub-Register Patrapur being signed. Thereafter, your Lordship may skip over. Your Lordship may kindly turn to next page, page 71. Subpara. On perusal of the above document marked by Exhibit 1 as well as Exhibit 2, it is clear that there is no ambiguity with regard to the passing of the title from the vendors of the plaintiff to the plaintiff. It is the settled position of law that the registered document carries the value presumption in its favor and the person challenging the same has
Presumption value, presumptive value.
That is next page, Lord, page 72. Page 70. Subpara. Since the law is well settled that the ROR neither creates nor extinguishes any title in favor of the patadar, and only the registered sale deed being the final and sole document for deciding a title. Besides this, as per the provisions of Indian Evidence Act and the Registration Act, a registered document is always carries the presumption of genuineness in favor of the registered document itself. In the present case at hand, the said presumption goes in favor of the plaintiff, but the defendant number 2 and 4, though challenge the sale deed on various grounds, except mere denial, no evidence is adduced for showing that the said document marked by the Exhibit 1 was not prepared genuinely. Hence, it is well presumed that RSD completely established the flow of title. Lords, in the trial court, I filed the original sale deed. Now, Lords, one of the defendant came up before the first appellate court, and your Lordship may kindly turn to page 24, running page 24.
Internal page account.
Internal page
9
of the first appellate court.
That will be better. Yes.
Lord, issue number 2. Whether the RSD 51 of 1987 is executed without flow of title of vendor and is liable to be declared as void and nullity. There lies the question. Lords, whether in absence of any counterclaim or appeal from the side of the defendant, Lord, whether the court itself can declare so modo. And second point is, Lord, the Article 58 of Limitation Act. It's a sale deed of 87. Limitation applies both to the court as well as this issue has been answered in affirmative. Lord, may kindly see the operative portion. Internal page 26. While setting aside the trial court's judgment, the learned first appellate court has declared this registered cell deed as null and void. Lords, I formulated, Lords, the question is, Lords, I filed the original registered cell deed, and nothing has been adduced from the side of defendant. That is how I have formulated the questions of law.
We can say A will do.
A, B, C, I think I leave it to a lordship.
Courtesy SK Pradhan, counsel for the appellant. There is the impugned judgment considering the submissions and the materials and the grounds raised. The second appeal is admitted on the following substantial questions of law. Page 13, A, B, or C. Hello. Issue notice by registered post, returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR, list this matter.
16th December.
In the week commencing 16th December.
Item 35.
May I please, Your Lordship? The defendant number 2, 3, and 4 are the appellants against confirming judgment.
2, 3, and 4.
2, 3, and 4.
Suit for?
Suit for declaration that the cancellation of the shop room that is the ground floor of the old jail of the plaintiff, the respondent one before good sale, is illegal, and the same may be set aside, and that may be re-allotted after cancelling a fresh allotment in favor of defendant 3 and 4. The fact of the case lies in this, my lord. In 2002, advertisement was issued by the defendant number 1 and 2. Defendant number 1 is respondent.
National Building Construction
Yes,
Corporation.
respondent 2 before your lordship.
Yes.
That shop rooms and other structures will be allotted, sold, and accordingly the plaintiff applied for one. That is shop room number 127. But he paid 3 installments out of 10. Thereafter, he did not pay. Accordingly, on 13/5/2003, his allotment was cancelled. Thereafter, the same was re-allotted on full payment to defendant number 3 and 4. 3 and 4. Thereafter, the suit has been filed. Now, what has happened, my lord? Only 2 dates is necessary for your lordship. My lord, 14/5/2023, the plaintiff filed the suit in the court of the civil judge, junior division, first court cutoff.
23.
Sorry, 2003, my lord, sorry.
2013.
Not 2003, my lord. I am coming to that, my lord. On 14/5/2003, he filed the suit in the court of the civil judge, junior division, first court. On being noticed, the defendant 1 and 2 objected that the court has no pecuniary jurisdiction. Therefore, the matter came up to High Court. This honorable court said, there is also a reported case that no, it is undervalued. The junior division has no pecuniary jurisdiction.
Yeah, 50,000.
Again?
ସେତେବେଳେ ଯୋଉ 50,000 ଥିଲା
ବର୍ତ୍ତମାନ ତ ସେ 50,000 ଅଛି ନା।
ହଁ ନାଇଁ ସେଇଟା ଅଣ୍ଡର ଭ୍ୟାଲ୍ୟୁ ବୋଲି କହିଲେ this is more than 50,000.
ସୁଟ୍ ଇଏର ଦୋକାନର ଭ୍ୟାଲୁଏସନ ଟା ଅଛି 4 ଲକ୍ଷ ନା 5 ଲକ୍ଷ କେତେ।
ତାହେଲେ ମୁନ୍ସିପ ପାଖରେ କେମିତି ହବ?
ବାସ୍ ତେଣୁ that suit continued before the municipal till 28/10/2003. Sorry, 13. On 28/10/2013, plaintiff was returned. Now 29/10/2013.
Why was this time gap for so long?
That depends upon the plaintiff because the judgment was passed before this by this honorable court, and thereafter he took.
ଏଇଠି pending stay ହେଇକି ରହିଥିବ।
ରହିଥିଲା ବାସ୍। ଯାହା he took return of the and your lord then he filed the suit before the civil judge senior division first court cutoff on 29/10/2013. My lord, here 2013 I am giving the emphasis, but in the and your lordship knows return of plaintiff from wrong court and filing in the proper court is not the continuation. It is subject to law of limitation. But if due diligence and good faith is shown, it can be condoned by virtue of section 14 of the Limitation Act. Limitation Act.
No, limitation ଦେଖିବା obviously vision. Because I think the same plaint with the endorsement is to be filed before the next court.
Yes, he has filed it.
যদি সেইটা হইছিল, I think that will save limitation. I mean
No,
wrong.
my lord, my submission
সেটা হলে
is,
কেতে
law is well
Order
settled.
7.
That is not continuation. It is a fresh suit for all purposes.
I may be wrong, Mr. Bag. What I'm saying is, দেখুন, Order 7 Rule 10, subject to the provisions of Rule 10A, the plaintiff shall at any stage of the suit be returned to be presented to the court in which the suit should have been instituted.
Again,
বুঝলে? Voilà. Procedure on returning the plaintiff, the judge shall endorse thereon the date of its presentation and return the name of the party presenting it and a brief statement of the reasons for returning. 10A has a power of court to fix a date of appearance in the court where plaint is to be filed after its return.
again.
So, law of limitation কথাটা
It's nahi again.
এখানে কিছু নাই।
Jodi court kahite both party to appear on certain circumstances, then limitation may not come. But once plaint is returned, that is transfer and returned.
সেই এন্ডোর্সমেন্টটা দেখিବାକୁ পড়ে প্লেন্টের
Yeah, yeah. Once whatever may be the endorsement, but once the plaint is returned, it is a fresh suit. If filed when filed in proper court, it is a fresh suit. That is a law that trial court and the first appellate court has considered that. There is no dispute, my lord. But my submission is,
dispute is with me, sir. I am unable to understand this.
my lord, then কালি কি আসবে this
No,
থেকে দিবা
লিখে নাই, মানে সেটা আমি not ম্যাটার
না,
চালু ম্যাটার
question is-
চালু ম্যাটারটা যেবার কেমন আছে
now question is, my lord, my submission is, your lordship may kindly see when your lordship is saying order 7 rule 6.
Order 7 Rule 6, yes.
Now my
Definitely.
first submission is return of plaint and presentation in proper court is not the continuation. That is also 2023 Supreme Court also. Now,
facts
6
are
your
to
lordship may kindly see.
Yes.
Though limitation cannot be condoned in a suit, but in certain circumstances, it can be condoned. And for that, rule 6, your lordship may kindly see.
Order 7 Rule 6 তো কোন
Where the suit is instituted after the expiration of the period of prescribed by the law of limitation, the plaintiff shall show the ground upon which exemption for such law is claimed. Then proviso is there. But here, after taking return, it is just filed. No exemption under this provision is made. And further, your lordship may kindly see section 14. No application. My lord, I understand, my lord. If he can satisfy that he was prosecuting the case before the munshi in due diligence and good faith, it can be condoned. But for that, an application is to be filed. Like section 5 petition, my lord. If there is a delay, it cannot be condoned suo motu. Only one Kerala decision or Karnataka decision is that it can be condoned suo motu. But no Supreme Court decision, all have said it can be condoned. But without application, no, it is not said. You'll also make kindly section 14, my lord. Section 14 of the Limitation Act.
Yes.
1. In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or of appeal or revision against the defendant, shall be excluded where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court which from the defect of jurisdiction or other cause of a like nature is unable to entertain it. So my submission is, he has to file plaintiff has to file an application along with the presentation of plaint, or he has to incorporate it in view of order 7 rule 6. It is nothing is there.
Yeah, but had you appeared before the Munsif court?
My lord, the defendant number 2 had appeared, but defendant 3 and 4 had not appeared. I will come to the defendant 3 and 4. They had not appeared. So notice was issued. Then they appeared. In before the civil justice in region first court. They in the written statement they took the plea of limitation. It is not a continuation. Everything. So now the trial court only said there is no limitation. The first appellate court said that in view of the decision of the apex court, the delay can be condoned. So much. Now this is one point so far limitation is. So whole suit is concerned. Now, the defendant number 3 and 4, who are the purchaser, and appellant number 2 and 3 before lordship, they purchased the sub-room in question on 13/5/2020. 203, my lord. They were not made parties in the suit before the Munshi. Even after return, they were not made parties. They were implemented by filing an application under Order 1 Rule 10. Much thereafter, it was allowed in 2015 and notice was issued. Now, your lordship, on this point, here is your lordship may kindly see Order 1 Rule 10 Sub Rule 5.
Yes.
5, my lord.
Yes.
Subject to the provisions of the Indian Limitation Act 1877, Section 22 of the proceeding as against any person aided as defendant shall be deemed to have begun only on the service of summons. So, defend number 3 and 4, my lord, I am not here, whether it will be a continuation or other things. That is one part. That is first point, my lord. Now, the second point is, these defend number 3 and 4 were not parties in the suit, and they were implemented for the first time by way of filing an application under Order 1 Rule 10, and notice was issued, and in person to notice they appeared in 2015. The cause of action arose in 2003. Now they were added as party in 2015. Everything has been exhibited. Now, so my lord, limitation will apply. Now, your lordship may kindly see, along with this, Section 21 of the Limitation Act. Let's go to it.
Yes.
Where after the institution of a suit, a new plaintiff or defendant is substituted or added, the suit shall, as regards him, be deemed to have been instituted when he was so made a party, provided a court have, where there is no such order by the trial court, who allowed the Order 1 Rule 10, whether that addition will go back to the date of filing of the suit or not. So it presupposes that it is from the date when the order was passed or someone was served on them as per Order 1 Rule 10 Sub Rule 5. So there is also limitation. But the appellate court has, that was completely ignored by trial court. First appellate court has said in the impugned order that is not applicable. So on points of limitation, these two grounds. Furthermore, next ground is, my lord, when the plaintiff, a provisional allotment was issued to him for the shop, and he paid only 2 installments. Thereafter, he did not pay. Thereafter, the shop room was cancelled. So my submission is that before filing the suit, as per the requirement of Appendix 47 and 48, he has not issued any notice and directly has filed the suit, and there is readiness and willingness has not been proved. So that is one ground. But after dismissing allowing the suit and dismissing the direction has been given to hand over the possession to the plaintiff of the suit. These are my 3 points, my lord. And lordship may kindly see the substantial question of law I have formulated, page 11, my lord.
Page
11 of the second
Yes,
page,
yes.
D, C and D. गोटे ही परिवार गोटा का आपण कर दे परिवार मो एतरे लेची section 3. So when the suit was filing a suit in the proper court after return is not a continuation, so section 3 of the Limitation Act will apply.
Section 3 is a general law.
Yes. So my only submission is without any application for condonation of delay as contained as section 14, or without incorporating exemption of limitation as per Order 7 Rule 6, limitation can be condoned sumoto. That is my 1 point, my lord. And next point.
So we'll say A, B, we'll say B.
B, my lord, is B.
Then we can say E also.
E. E.
E will do.
Again.
A, B and E.
E and I again. जो सप्रूम टा पोजेशन दवा पाई कहले सेटिस्फाइड कर दे रीअलॉटमेंट
I cannot be a substantial question of law. I.
Let's make a formulated whether the direction to
Now, heard Sri Bamsidhar Bhatt, learned counsel for the appellants. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Page 11, right? B, then E, and then I. Issue notice to the respondent. The registered post, returnable within 4 weeks. The requisites be filed within 3 working days. LCR be called for. List this matter on
16th December.
Stay
of further proceeding of the execution case.
IA 748 of 2024. Further proceedings in execution case number
34 of 2023.
pending before such court.
Third additional civil judge
Shall be state, shall remain state till the next date.
Item 36.
There is another for dispensing with filing of certificate copy. So that is infructuous. Acha.
Appeal.
36.
The defendant is the appellant against a confirming judgment, suit for eviction. Defendant is the appellant. The plaintiff case is that he, along with three brothers, purchased this property way back in 1956 jointly. And there is a oral partition, and in the oral partition, the property had fallen to the share, portion of the property had fallen to the share of the plaintiff. And that by another unregistered deed of family settlement, this oral partition was also accepted. That is the entire case. But the defendant's case is, and this property was let out to the defendant, and defendant continued and he did not pay the rent. So the suit was filed for eviction after giving notice on section 106. The defense case is, first is, you have no title, plaintiff has no title, and the suit is bad for non-gender parties because others have not been made parties. Then the third is that so far relations of landlord tenant, no issue has been framed by the trial court. So far the defendant denied the relationship of landlord tenant, denied the title of the plaintiff, and neither the title of the plaintiff was the issue, nor the issue with regard to the establishment of relationship of landlord tenant. And no issue also with regard to the non-gender parties. Specifically, it was raised in the written statement. And the appellate, the trial court proceeded with the matter and decreed the suit without framing the issue. And the appellate court, though he has taken note of my contentions, so far as non-gender party, so far the title, so far the relationship landlord tenant, but no finding whatsoever has been given. No finding whatsoever has been given by the appellate court. Therefore, the order for 31, as you also I've got a judgment of 2020 Supreme Court. If you also look to that. And the other one is a non-gender party. If suppose non-gender parties, that has been completely ignored by both the trial court as well as the appellate. Completely ignored. You'll also look to the judgment. Then I'll take your worship to the
Paragraph?
Paragraph 14. Paragraph 14. This is 2020 Supreme Court Civil Appeal number 1485/2020. It is settled position of law that an appeal is a continuation of the proceeding of the original court. Ordinarily, the appellate jurisdiction involves a re-hearing on law as well as on the fact and is invoked by an aggrieved person. The first appeal is a valuable right of the appellate, and therein all question of fact and law decided by the trial court are open for reconsideration. Therefore, the first appellate court is required to address itself to all the issues and decide the case by giving reasons. The court of first appeal must record its finding only after dealing with all issues of law as well as fact and with evidence, oral as well as documentary, laid by parties. The judgment of the first appellate court must display conscious application of mind and record findings supported by reasons on all issues and contentions. Then let's kindly come to paragraph 17. A judgment of 2015-1 SEC was quoted, para 17. In Vinod Kumar Swanso, this court has reiterated the principle to be borne in mind while disposing of the first appeal as under. Again, that quotation, paragraph 15. B, so and so, 2010-13 SCC page 530. This court, taking note of all of the earlier judgment of this court, reiterated the aforementioned principle with these words. Quotation 3. How the regular first appeal is to be disposed of by the appellate court, High Court, has been considered by this court in various decisions. Order 41 CPC deals with appeals from the original decree. Amongst the various rules, Rule 31 mandates that the judgment of the appellate court shall state A, the point of for determination, B, the decision thereon, C, the reason for the decision, and D, where the decree appealed from is reversed or varied.
So that's all.
That's right. That's it. So if you also look to the appellate court judgment, appellate court has not whispered single word about non-gender parties. Written statement have specifically said that the suit is defective for non-gender party. The another judgment will also be looked at. So far non-gender party is concerned. This is a suit for also arising out of a suit for eviction. Of course, this is a judgment of Delhi High Court. The persuasive value. If you also will come to paragraph, a suit for eviction, same thing. You also come to paragraph 12.
Yes.
The defendant has raised various preliminary objections.
Yes.
Various preliminary objections in the written statement come counterclaim. The defendant submit that plaintiff have no locus standi to institute and file the suit, as they are not the owners of the suit property. In furtherance of this contention, the defendant submit that perpetual lease deed entered into between DDA and the plaintiff was cancelled by notice dated so and so, and the DDA reclaimed the possession of the plot of land and the structure standing thereon. The defendant further submit that the suit is bad for non-gender of the following necessary parties. Then you also kindly come to the issues were framed in paragraph 15.
Yes.
Whether by the order dated so and so, the following issues are framed by the trial court. Whether the license of the defendant was legally and validly terminated before the suit. 2. Whether the license fee of the suit premises was 20,000 per month during so and so. Whether the plaintiff are entitled to occupation charge of 1 lakh at any time, at any other rate per month from June 2003 till month of August 2005. To what extent is the defendant under obligation to pay electricity dues and water bills? Next. Whether the suit is barred by law of limitation. Whether the suit is maintainable in view of the provision of Order 41 of the Specific Relief Act. Whether the suit is without cause of action against the defendant. Then 8. Whether the plaintiff have not come to the court with a clean hand. Then whether the suit is undervalued for the purpose of court fee.
Sir, I'll admit it. I'll admit it. I'll admit it on this E is very important. E.
Yes.
E, D and E.
D and E.
Heard Sri Buddhadev Rautrai, Learned Senior Counsel with J. Biswal, Learned Counsel appearing for the appellant.
B and E. B and E.
B and E.
Yes.
Appellant. Peruse the impugned judgment. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Page 8 or D or E.
Execution case further proceeding of the
issue notice to the respondents by registered post, returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR. List this matter. 16th December. Also, IE. Further proceeding in execution case number so and so shall remain stayed till the next date.
3 of 2020.
Hearing if anybody is hearing
Item number 2.
The case actually very. He claimed title by adverse possession and permanent injunction. Though in fact the entire pleading is based on the fact that he has got a Amalwa Pata and also after vesting he was continuing on as a tenant on the state. So actually, for that purpose, a case is pending. It is
RF case. RF case is 213.
RF case number 213 of 75. So initially that was dismissed. Then an LE case was initiated. In the LE case, the appellate authority held, revisional authority held that you should have approached the RE case has to be revived and the matter has to be adjudicated there. At that stage, they wanted to evict me. So I filed the suit. So government is to find out whether that case is pending or not. That is a case under section 8(1).
I would request my Lord Senior to give me the details.
That is the RF case 213.
Before?
Plaintiff.
Tahsildar Baleshwar.
213 of?
1975.
Tahsildar Sadar Baleshwar.
Heard further arguments? Place this matter on. Shorted call. Finish up the on 7th, in the week commencing 7th October. In the meantime, Learned State Counsel shall obtain instructions regarding कौन से केस है? RF case number
213 of 1975.
213 of 1975 said to be pending before of the court of
Tahsildar Sadar Baleshwar.
Tahsildar Sadar Baleshwar.
Rent fixation.
Rent fixation है तो? Hearing.
Item number 37.
Pass over.
Item number 39.
39. Pass over.
Item number 40.
40 is yours, sir. Other side is Mr. Mahathi is ready. Pass over for the day, sir. Pass over for the day.
Pass over. Almost day is over.
Average sir 35 minutes ଅଛି ତ
41, 49. 40, 41.
All right. Okay, 41 is somebody
Item
else is appearing.
41, I pray some more time because I am appearing for respondent number 1 who is a liquidated society.
All right, 41 I can adjourn it. 40 टा pass over को रखिली. 41 will adjourn it. 41 टा 40 टा pass over है ना? मतलब for the day. 41 list this matter. This is a 2012 matter, Mr. Nanda. I will not grant you further time.
1 week after, just like.
All right. 1 week after माने week commencing 23rd.
Yes.
List this matter in the week commencing 23rd September as paid for by Sri KP Nanda, Learned Counsel for the respondents. Yes.
Obliged, man.
Item number 42.
42.
What's the password for the week?
Password for the week. You know କଥା ଆପଣ ଶିଖିଲେଣି ମତେ password for the week ନା adjournment. ଏଇ week ର ଏଟା ଆର week ରେ ବି continue କରିବ ବୋଲି ଆପଣ ଜାଣିଛନ୍ତି.
Short adjournment.
नहीं short कौन long कौन मैं ये कौन मैं बुझी पाना but कौन को बुझते. List this matter next week. Yes.
17.
हाँ सही.
Item 43.
43.
Member respondent.
Mr. Bhuiya. Dismiss कर दो कौन नॉजिल dismiss कर दो ओ pass over
से dismiss हेले लाभ किसी ने और काली की बसे था
हाँ pass over
44
44
Passing for the.
नहीं करो आराम करो
I'll prepare, but tomorrow.
नहीं why have you not prepared?
Sir.
You will prepare me ना you do a favor on the court or what? Why have you not prepared? All cases were coming and asking for pass over.
For the respondents.
Oh, you are for the respondent. Also, respondent, what is the case of the respondent? Tell me. Body when खाली असली कौन? All right, pass over. 45.
45 next week.
List this matter in the week commencing
17 September.
17 September.
Item 46.
Yes.
May I please your lordship? Another respondent already appeared, man. They have filed the B number. Their name is not reflected. Mr. Vivekananda V. They have appeared for all.
Even if his name is there in the cause list, he doesn't appear. So his name appearing or not appearing in the cause list doesn't matter.
Yes.
I will hear from Mr. Hota. He is the appellant. I will begin. I will keep it part-heard. Ask him to appear.
ଆମର କାଲି ରିପ୍ଲାଇଟା ଆମେ
ହଁ ଭଲ କଥା କିଏ ମନା କରୁଛନ୍ତି ଆପଣ ନୋଟ କରନ୍ତୁ ଟେକ୍ ନୋଟ ଅଫ ହ୍ୱାଟ ଏଭର ହି ଇଜ ଆର୍ଗୁଇଂ
Well, let us go to the
there is a petition for acceptance of additional evidence
that's
that we will take it up.
No, just no, let us let us take it fast, man.
Yes,
Madam May, these are the documents, the certified copies we applied as per the court's order, madam, court at once order, but this was not supplied. At last, we came to know that it has been already digitized. So from digitized copy, we are filing it.
no, digitized copy also you can get certified copies.
No, that also denied by the Tahsildar, madam.
Okay.
They did not give at all. They did not respond to the certified copy application.
Okay.
So it took time. My lord, when look at, it is regarding the respondent number 1, the conduct of the respondent number 1. He was having Toji connections with the Tahsil. Because from 1983, he had having bricks business, so the lease to be taken for the Toji connection is there. So whosoever the Tahsildar be, he will pocket it. So, may kindly see the respondent number 1 is shown as the adopted son of Devendra Singh. His natural father is Gauri Shankar Sundar. Madam, kindly look at Annex 2. Madam, before that, let us go to the Annex 22, page 17. My lord, this is we asked for asked the Tahsildar to certify whether he is a landless person. Respondent number 1. Now the inquiry report of applications of the appellant, with reference to it reveals that the Gajraj Singh is not a landless person. There is no information available, RI Office Bandwal, about the list of landless beneficiary and the amount of land to them between the year 1990 to Hirarama and Khada. So he is not a landless person. But may I kindly look at my lord, Annex 23 the next.
My lord, no annexure has been given, my lord.
No,
yes.
no, you see, whenever it is filed before the court itself, it is filed before the court.
Court को दिले हमको
I'm sorry for this.
Appeal memo copy देजन, किन्तु annexure देना, no annexure is there.
Copy. Annexure, I am telling this addition of this additional evidence. This is now we are working with the IA number.
Have you given copy of? Have you
yes,
given?
Before the my lords.
Yes.
My lord, we look at Annex 23 next page. Here, the record shows he has obtained 2 acres of land on leasement. Madam, may kindly see first line. A case 1/85 तारीखरु so and so मुताबक आदेश क्रमे खाता नंबर डैश टू डैश खारिज करा जाई खाता नंबर एतिकी रे एकर 2 एकर 2 who does so he is not a landless person, but he has got the lease of the lease of 2 acres on the basis of landless person. My next is Annex 6, Annex 2, 21-22.
Annex
2, 21-22.
21-22 कौन?
21, 22 phase.
Annexure 2, yes.
The government land, he has been leased out AC 0.32 and a 0.06. This is also leased out land as a landless person. Number 3 is Annexure 6, 2930. This is also it has been taken away. The land which has been.
All right. So you want the court to believe that he, despite being a landless person, despite not being a landless person,
then also he
obtained some lease.
Lease.
All right. Now, how is it? So we will have to come back to
coming to that. Slowly, my lord. My lord, the natural father, my lord, may kindly see, these are the leases he has taken. Now, being natural father, my lord, the respondent wants natural father. My lord, kindly see Annexure 2, Annexure 4, Annexure 5, Annexure 6, Annexure 7.
Yes.
Annexure 8, Annexure 9.
What does it mention?
There, he showed himself in the year 2022, 2006, 2005, 2006, 2007, 2011, and 2013 as a son of Gauri Shankar Singh. Natural father. Hello, kindly.
What is his name?
His original name is Birendra Kumar Singh. But now he has changed his name to Gajraj Singh. Now the interplay of names and manipulation of records. Now with natural name, my lord, may kindly see Annexure 1, page 1920.
Padmaraya Singh, Sri Birendra Kumar Singh.
See, this is the original name, my lord. Wife name, Padmaraya Singh is wife's name. And my lord, kindly turn to Annexure 3, page 23-24.
Yes.
Here, Padmaraya Singh, wife of Gajraj Singh. This change, my lord. It is in year 2009, my lord. 2009. And the Annexure 1 was 2002. My lord, now we'll go to the change name, my lord. My lord, the name is changed. My lord, already got it, my lord, from the 7, 10, etc. Now, as adopted son, he has shown as 11 and 12.
Eleven is Annexure 11.
Annexure.
There's a mutation order. Received son of Gauri Shankar Singh.
That is a part of the suit land case, my lord. The only thing is there he has been shown as the son of Devendra Singh. Originally, he is son of Gauri Shankar Singh. My lord, the page 42, this Annexure 11, kindly see below 7 verses after verses. My lord, got it, my lord.
Gajraj Singh.
That's a son of Devendra Singh. My lord, got it, my lord.
Sorry to interrupt my learned senior in this matter. My learned senior, Mr. Bhuya, had appeared in the matter on 28th of August. His name has not been reflected in the...
No issues, no issues. He will appear tomorrow. I am not closing the matter today. He's just beginning. I'll keep it parted.
Copy of the said IA may also be served.
Copy already, notice already served.
IA.
IA notice it like?
Oh, I will notice the Johnny Children, acceptable. I do not know whether he has appeared or not.
No, IA notice jaiti lagi.
No. On the very...
You give a copy, he'll reply tomorrow. Tomorrow, day after tomorrow. Tomorrow, day after. I am not closing it today.
Day after tomorrow.
You wait. So this is all about the additional evidence.
I learned. Now the question is, my lord, kindly see the annexer, regarding the suit land, my lord, kindly go to the annexer 14, page 54, 55.
Yes.
This is the original suit land recorded by the settlement, my lord. There, may I kindly see, Khata number is there, 180 or 108 by 47. And the next page, my lord, 8 acres. Now, this respondent number 1, others are not contesting with difference. The respondent 1 is all in all. So respondent 1, my lord, may just asking me the mutation case record, my lord, annexer, the 11. Annexer 1139, my lord. What they did, my lord, this annexer 14 suit land was mutated in their favor in the name of all the brothers jointly. Behind the back of the appellants, without notice, without inquiry in presence of the these appellants, this thing, my lord, may kindly see the mutation record, my lord, may kindly see annexer 11.
I am looking at it.
My lord, see. My lord, thereafter, my lord, kindly see annexer page 42 where I have shown earlier.
Yes.
That was, my lord, kindly see the top. Under section 19C of the OLR Act for partition of the suit. These 8 acres recorded jointly, that is annexer.
All right.
Recorded jointly. Thereafter, they demarcated. High arrows have been created. Mind you, kindly see, this is high arrows. Annexer 16, 17, 18, 19. Got it?
Yes.
These are all behind our back. Right, got it? Madam, when look at least the regarding the name of change, etc., annexer 24, 25, that is all from Birendra Singh, the original name, to Gajra Singh. That is there. Well, annexer 24, 25, they are notes. And 26 to 28, my lord, this is the physical possession notice board, 4 corners of the suit land. But now, my lord, what happened? It is all done behind the back. In 2003, this is done in 2000 and 2001. 2003, what they did, out of quarrel with the respondent 1, with the appellants, came to know that they have been recorded. So it is 2003 we came to know that it has been recorded. So immediately we moved to next tribunal. So we went to the appellate court. Suppler is has nexus with this Tahsildar. While doing so, Tahsildar what he did in this case, the mutation appeal number 12 of 2003 upheld the order of the Tahsildar. That means the settlement in favor of the joint property was kept intact. And regarding the annexer 1142 page, my lord, it was set aside. My lord got it, man. So now we came to know when we are collecting the documents that this suit land after partition, this respondent 1 has sold out the land under annexer 21 and 20 and 21. This we came to know now, my lord. It should have been corrected by the Tahsildar below in 2005. It was not done. Now kindly see Annex 20. It was sold by this gentleman Annex.
Annex 20 is ROR.
ROR. They have already got done. ROR. They are sold away in 2005 perhaps. And 2006 there is a mutation case. One is Annex 20, another is 21. My lord. So 1 acre has been sold away. That is why we have filed IA number 25. This is 24, 1024. That is why you filed annexure IA number 25, 1025. Madam, may kindly see. I have stated in para 3 matter that the illegal order of 13/6/2001 passed by Tahsildar in mutation case number 425 of 2001 by partitioning the suit line under creation of 4 khatas was held to be not maintainable and set aside by the appellate authority in mutation appeal number 11 of 2003. As such, the order dated 13/6/2001 was a nullity in the eye of law as per the order dated 27/5/2005. So passed. 2005, so passed. The said appellate authority was not challenged in any revision by the respondents. So the order was effective and final. But now we are getting the documents in the exam. It has not been reversed. That is why I came before my lords that we should be protected, the suit land to be protected. Number 1. This is regarding the additional evidence. Why we have kept on the court directed earlier, my lord, the coordinate bench, that why you have added 3 names, because proper identification cannot be done without naming the person in proper. So we have done it in the second appeal.
Yes.
My lord, now we'll go to, my lord, got some smell of the case, my lord.
Yes.
Behind the back down, what is that land? That is to be shown, my lord. My lord, may kindly see. The story is, my lord, the annexure 1, this exhibit 1 document, my lord. I have my land, the Ganeshwar Singh was the recorded holder. Annexure 1 kindly be seen, my lord.
Annexure 1 of the additional evidence petition.
No. Annexure 1 of the original trial suit.
Annexure 1.
Exhibit 1, I'm telling.
What was the suit for?
Suit for permanent, my lord, declaration of right at interest.
Exhibit came. Exhibit.
Declare plain to be different, title to be settled with settled land,
hard copy.
Their position be confirmed and alternative. If court finds.
Just a moment.
My.
ये जिते सुनो हियरिंग को आसला पूर्व सबू जिते हार्ड फाइल ने सब को एग्जिबिट मार्क करके तमे फ्लैग मार्क करो हैला इधर किछि नै इधर देखो लिस्ट ऑफ एग्जिबिट लिखा है लिस्ट ऑफ एग्जिबिट बाहर कला अन्य जिंस होछ
It's all right, man. All right. I'm placing the plaintiff.
मतलब brief टा खाली कह दो we'll go continue to
plaint. I'm sir. It's a 2-page only.
Page plaint.
Plaint. Original plaint, madam.
कुछ भारी कष्ट हो गया.
Madam, from this it will be.
Yes. Substituted plaint. कौन था?
Madam.
There's a genealogy given.
Madam.
There's a genealogy given in the plaint.
Genealogy given. My lord, because it is given in the order sheet to adopted son, that's why they have given the adopted son, and etc. That, my lord, para 4. My lord, the para 3, the Joydev Singh is long dead. Joydev Singh is the Ganeshwar Singh's father. His sons are separated in all respects between themselves during the time of Joydev Singh. Joydev Singh died in the year 1945, prior to 1945. Joydev Singh. Joydev Singh is the Kharposdar. Kharposdar means doing the duty of Jamindar's representative, collecting revenues, paying them. So for duty, for discharging such duty, a separate khata was given to them. Some area was given to them, which was recorded as khunti number 1, khata number 1. That was called seer property. Now, for the maintenance of the children, the family members, now given khudkast property. So khudkast property in khata number 2. That is jointly recorded along with Jaydev Singh, and khata 1 recorded in the name of Jaydev Singh alone. So now khata 1, khata 2, my lord, it is clear. Now, that much of the lands belonging to Ganeshwar Singh and also other villages were acquired under Hirakud Dam project. Hence, a measure of resettlement, because it was acquisition was 70 acres from khata number 1 of Ganeshwar and 22 acres from khunti number 2. But the joints, all joints. Hence, as a measure of resettlement, the government took decision to allot land to the land trustees. That is on application. In pursuance thereof, revenue miscase number so and so in 1956-57, the then additional commissioner Chello settled 8 acres of land with Ganeshwar Singh as per rough map attached to the plan. The stipulation of settlement was that allotee should complete reclamation within 2 years from the date of order. As such, within stipulated date, Ganeshwar reclaimed the said land in his own right title interest. Hence, notice of allotment is issued so and so. Moreover, none of the other brothers of Ganeshwar Singh were allotted any land in the aforesaid miscase, nor they reclaimed nor they possessed. Got it, man? The land allotted to Ganeshwar Singh was reclaimed and possessed by which have been described in detail today. And that annexure 14 of the additional documents. That in pursuance to government order of Revenue Department, letter dated 17/5/90, that is Exhibit 4. Letter number so and so by that is already in the file given at the time of filing the claim. Respective Tahsildar directed to take up the matter, mutating the settling the names of the allotees referred to above in the name of the legal heirs after due. Well, this may be noted. It will be settled if they are dead. Then that was called DC Patta, Deputy Commissioner Patta. That 57 allotment. That is under Annexure 2. Ganeshwar Singh's name stands at a serial number 18. So that the government came with the scheme that it should be settled with the legal heir. That is Annexure 4 and other documents filed with the plaintiff. As per the order dated 29/8/2000 and 1/11/2000, the Tahsildar order that as per the Amins S-Bag and B. Mishra, 2 Amins pocketed by Respondent number 1, report the landlay allottees were not in possession. I have already shown the possession matter. The Tahsildar ordered to prepare the record for mutation in the name of DC permission holder, none other else. It was therefore clear that the order was to mutate the lands of the legal heirs of the Ganeshwar Singh, as Ganeshwar was dead by that time. Now, para 6. The plaintiffs informed the additional Tahsildar took up the matter, finding the legal heirs. In so doing, he merely dropped the complete genealogy of Jaydev Singh. Now, what they did, my lord? They wanted that it is for the joint family property. This is done. So they put a genealogy up from Jaydev Singh so that this Ganeshwar Singh and his brothers will be included. That is what happened in this case. And that too, it was behind the back in absence of the appellants. In the complete genealogy, Jaydev Singh, father of Ganeshwar, and sent paper signature for sub-collector Jharsuguda. My lord got it. My lord. That is why Jharsuguda, the sub-collector rejected our appeal. No notice was served on the descendants of the Ganeshwar Singh, nor they present during the preparation of this record. No field inquiry was held as to the actual position of the scheduled land. Whole thing was an IWAS behind the back of the legal descendants of the Ganeshwar Singh at the instance of Bajraj Singh and other sons of Jaidev Singh's second wife. However, they obtained the order of mutation 29/5/2000 from Archal Tasudar in their favor because it was a joint property, and then after immediately they partitioned the property. As a matter of fact, as already stated, besides Ganeshwar Singh and his descendant, no other person ever possessed a scheduled land, and at no point of time they were intimated to be mutated. The plaintiffs believes that the whole proceeding relating to mutation and settlement of different number 1 to 6 have been done in a collusive manner, antedating order and documents. On coming to know all these illegal mutation, plaintiffs son defendant number so and so filed appeal, mutation appeal number so and so before the sub-collector Jharsuguda, but taking a wrong view, sub-collector dismissed the appeal in our in the order dated 16/9/2005. So 16 that the order earlier order of Tahsildar marked in 16/9/2005.
Yes.
Now this order is under challenge. After this only civil suit filed. Well, paints a bad side view is come.
Yes. Yes.
Now thereafter what happened? Malad may look at the trials court record. The judgment of the trial court. Detailed discussion, my lord, para 2.
Is it necessary? No, I don't.
No, not necessary, but I'm just specifying.
Yes.
That detailed discussion regarding this fact.
Yes. Let us go to the issues.
Let
us go to the issues now.
Issues. Now, issues will go, my lord. The issues they have decided, there's 9 issues, my lord. I will kindly see the issues at page 8.
Yes.
Now, for the benefit of the case, the trial court took issue number 4 and 5 together regarding the right title interest, etc. My lord, may kindly see issue number 4 and 5. Now they discuss the fact in detail, my lord. They say, we said our plea was that it's a scheme of the government. And the land allotted was a grant under the government. My lord, it's a grant of government. Now, we said, my lord, may kindly see exhibit 2 can be. Can see.
সেটা তো হুনে থেকে অসুবিধা আছে।
ওখানে দেখিয়ে দেবো, গোটা পাঠিয়ে দেবো।
You refer to it. We'll see it tomorrow. We'll refer to it. What is there in that exhibit 2? What is that document? What do you want?
2, my lord, the original exhibit can be seen.
Copy order for the additional deputy commissioner, Hirakud Land Organization.
Yes. Now next page, my lord, page 8, column 18. My lord, got it, my lord.
Column 8 is Ganjia Kisan.
My lord?
8 though. Rajara now.
No, next page. Another 2 pages.
Yes.
18.
18. Ganeshwar Singh.
My lord.
18
My lord, with exhibit 1, exhibit 2, it will be better, my lord, may see both. So that for the time being, exhibit 1, this is the document from the Erakud Dam project filed before the court as exhibit 1. Because the person has come as exhibit 1, as PW1.
Ganeshwar Singh.
But no. Another matter. He has filed it. It's a government document, may kindly see.
Yes.
From that, my lord, exhibit 1, may kindly see 95, serial number 95, 97.
96 achi.
No, no, before that. Previous page. 95, 97. Serial number. Ugre. Land was acquired.
Yes.
Ugre. Got it, my lord?
Yes, yes.
95 and 97.
Yes.
In Exhibit 2,
Ugre Kisan.
In 95 and 97, their lands were acquired.
Yes.
That was Exhibit 1. Exhibit 2, that the paper I have given, my lord, earlier.
Yes.
My lord, kindly see Exhibit serial number 4.
Ugre Kisan.
Ugre. Same person. As a resettler on application. How much, madam?
2 acres.
2 acres of land. Now, similarly, my lord, may kindly see 97A, Ganjia. 97A of the Exhibit 1. Now, Exhibit 2, 8.
Two acres.
2 acres. My lord, may kindly see Exhibit 6, this Exhibit 1, 64.
Yes.
Kartiko. In Exhibit 7, 2, serial number 19, 2 acres.
Good.
My lord, got it, my lord. Thereafter, my lord, kindly see.
No, what is the point, please?
Because that is vital. This is dealt by the trial court, also dealt by the appellate. That's why I'm submitting. First, facts be clear so that things will be clear. Now, Exhibit 155. Exhibit 155, serial. Chandrani, Kukila, Samo. Got it, man?
Yes.
Now, these are all one family minors. Their lands, some 6 acres were acquired. On application, they were given 3 sons, given 2 acres each. My lord, kindly see Exhibit 2, 14, 15, 16. 2 acres each. Why I am saying this, my lord? This is our plea that whosoever applied got it, irrespective of the lands acquired. And got it. They said, the appellate court said that it is extravagant. Irrelevant facts. Irrelevant facts. That I will go to during the judgments night. Extravagant, irrelevant facts. Well, I got it, man. So, Madam, may I kindly go to shall I go to the trial court judgment?
We will continue tomorrow. Yeah.
Obliged.
Serial number? Interim order to continue. We will continue tomorrow.
Item 48. And for the respondent, only for the no, didn't roll.
Let the appellant come. Let the appellant come. Oh, sorry. How is it? LCR order set no exhibit amendment. Already poison training exhibit